Welcome, everybody. The House Courts of Justice Committee will come to order. If Madam Clerk, if you could open the roll for attendance.
Madam Chair, would you like for me to call the names of those that haven't indicated their presence on the electronic voting device?
Yes, please. Sorry.
Delegate Watts.
Here.
Delegate Watts is present. Delegate Lindsay.
Here.
Delegate Lindsay is present. Delegate Mullen. Delegate Adams of Pennsylvania. Delegate Campbell of Smith. Delegate Mieres. Madam Chair, a quorum is present.
Thank you, Madam Clerk.
And Madam Chair, I apologize. This is Delegate Mullen. I am present.
Great.
Delegate Mullen is present.
Right, thank you. We will start with the first block, which is administrative items. First bill is SB 5012, Senator Suderline, Virginia Freedom of Information Act, Virginia Parole Board member votes. This bill is the same as HB 5092, which was tabled and referred to the FOIA Commission by the Committee on Public Safety.
Madam Chairman?
Yes.
Delegate Simon here. I would move then that we that we lay SB 5012 on the table and refer with a letter from the chair to the chair and vice chair of the FOIA Council, asking the FOIA Council to take up this issue.
Second.
The FOIA chair actually voted.
Table the bill with a letter from me going to the FOIA Council for study. All in favor?
Aye.
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 Oh, it is recorded vote. I'm sorry, it's a recorded vote. Oh, did he wants to talk? Oh. All right, so I'm going to ask the clerk to destroy the roll. I understand the senator is with us and would like to say some words. So, Senator Suderline, welcome. I can hear him.
Thank you. The bill was actually considered in the Senate. No one addressed any issue with the FOIA Council there. It's something that's done routinely in other states, and pretty much every other board in Virginia's votes are public. And that's what the bill does. So I'm not really sure what the FOIA Council has to look at. It's a policy decision of, does the General Assembly believe that the public should know who's voting on the parole issues in the same way the public gets to know who the Commonwealth attorney that prosecuted the case was, who the judge that oversaw the trial, any appellate judges. That's what this is about.
All right, and thank you. I tend to want to give it the same treatment because that's what the Public Safety Committee has done, sent it to FOIA Council, and there is an ongoing study at the Crime Commission. So what's the pleasure of the committee?
Madam Chairman?
Yes.
Yeah, so again, I understand what what Senator is saying. I think that we did already refer an identical bill, and we tend to try and be consistent with our treatment of House and Senate bills. referring to the FOIA council doesn't mean that we're not going to revisit this issue and that we're not going to address the concerns that the senator raises. And it may very well be that we get the same outcome. But I just think that it's worthwhile to give this bill the extra time and attention that it needs, and that we decided to give to the House version. So I would again move that we lay SB 5012 on the table with a letter from the chairman to the FOIA council asking them to take this up with all deliberate speed.
Second.
It's been motion and second that SB 5012 be tabled with a letter from me to the FOIA council. All members wishing to vote, please do so on the electronic voting board.
Delegate Lindsay. Delegate Campbell of Smith. Delegate Liares.
Delegate Lindsay is a yes.
Delegate Lindsay is a yes.
Motion passes 13-6. All right, next is Senate Bill 5050. I believe Senator Obenshain is with us.
Madam Chair,
Yes.
this is Delegate Adams. I just wanted to note my presence. I wasn't here when the roll call was taken.
Oh, okay. Thank you.
I was having problems, actually. Thank you.
All right, thank you. There he is. Hi, Senator Obenshain.
Well, good afternoon. It's good to be with you.
Thanks for being here. SB 5050. You wanted to. Yes.
Sure. Madam Chair, members of the committee, this is a bill that does not have a House counterpart or companion. It passed the Senate unanimously after some work was done to try and address some of the technical components of it. This is a transparency bill dealing with the parole board. A lot has been said about actions of the parole board over the past few months. This doesn't really get to the heart of those issues at all. This just deals with transparency issues, and one of the technical problems that came up, as many of you may remember, there were multiple news stories about inmates who were being released from the Department of Corrections without the requisite period of time elapsing between notification of law enforcement and victims. One of the objections voiced by the parole board was, we don't have any control over that. This is the decision to release is made by the Department of Corrections. Working with Senator Servell, we addressed that in here to make it clear that it is the responsibility of the Department of Corrections, not the parole board, to make sure that the appropriate period of time has passed before these inmates are released, in order to make that more clear. The parole board really doesn't have control over that, and I think that is a mechanical change that will avoid that kind of confusion and, quite frankly, finger pointing in the future. Many of the criticisms that have been leveled at the parole board may be debatable. That, I think, is a fair point that members of the parole board made. Second, it addresses some of the transparency issues that are different from those that were addressed by Senator Suderline. With respect to the Vincent Martin release, Senator Morrissey and I had a robust dialogue about that very issue, and Senator Morrissey made a very valid point that Mr. Martin had served more than 40 years in prison. One of the transparency issues that is addressed by this bill is that when the parole board votes on a decision release, one of the points of information that it would be required to publish is the period of time that somebody has served. So if somebody has served 40 years, I think that would blunt some of the criticism. If, on the other hand, they've served 5 years for a murder, I think that is a very valid piece of data that the public should have. Also disclosed would be the offense committed and the jurisdiction in which the offense had been committed, so that people in jurisdictions affected certainly would have those pieces of information. So that's all that this bill really does. And as I said, it received unanimous bipartisan support in the Senate.
Delegate Simon?
Madam Chairman, I understand that this, we heard a lot of bills during the 2020 session about parole and early release and reform. And I think we generally took, and some of them had to deal with underlying crimes, some of them had to deal with the parole board's process and transparency requirements, and a lot of things that deal with a lot of similar issues. And I think that the posture this committee's taken on those bills was that we wanted to look at them all as comprehensively, all these issues together. And I think the Crime Commission is currently studying a lot of these issues that we referred to them during the 2020 session. It seems to me that this bill probably fits in pretty well with what the Crime Commission is already undertaking. And a lot of these, maybe some great ideas in here that we can put into the larger study. But I think that this bill is probably best sent there so we can see how this fits in with what's already underway at the Crime Commission. So with that, I would move that we lay this bill on the table with a letter from the chairman of the committee to the chairman of the Crime Commission, referring this bill to be part of that larger ongoing study of parole and early release issues.
Second.
Okay, it's been motion and second that SB 5050 be laid on the table with a letter from me to me asking it to be included in the study in the Crime Commission, which actually does include the transparency issues as well. So members wishing to vote, please do so on the electronic voting board. Okay, good.
Delegate Lindsay?
Delegate Lindsay is a nay.
Delegate Campbell? Delegate Mieres?
I'm just talking away. Sorry. Thank you. Y'all missed my beautiful performance. I apologize. Thank you, Senator Obenshain. We're going to move.
Thank you for allowing me to be heard.
Absolutely. Thank you. Next is Block 2. These are Senate bills are similar to House bills. First is Senate Bill 5024, Senator Lucas. Law enforcement attorney general authorized to file civil suit or inquire into any unlawful practice. It's similar to HB 5072, Delegate Lopez. Are the bills, I need to ask council, are the bills exactly the same or are they similar?
Good afternoon. Can you hear me?
Yes, hi, Senator. Welcome.
Madam Chair, this is Taylor May with Legislative,
Yes.
and they are not identical as of right now, but there is a conforming amendment that should be posting to LIS soon that would just remove, there's one sentence that was added in the Senate that is at the end of subsection C of SB 5024 that provides that the Attorney General may include as part of a conciliation agreement a provision that the locality shall be ineligible for funding under Article 8 of Chapter 1 of Title 9.1 upon a finding by any court of the Commonwealth that such locality is failing to comply with the conciliation agreement. And upon such a finding, the court shall declare the locality ineligible for funding until the locality comes into compliance with such agreement. So the amendment would strike that sentence, and once that's stricken, it would be identical to Delegate Lopez's HB 5072. The committee adopts that.
Yes, Delegate Mullen.
I never want to go sideways with Delegate, I'm sorry, Senator
Oh,
Lucas.
you just did it.
You just went sideways.
Okay. I never want to go sideways with Senator Lucas. Senator Lucas, is this the way that you want this to be able to go?
Well, it was my understanding that language strengthened the bill, and I think that's what the Attorney General preferred. And unless I'm mistaken, I think the way the bill is currently is the way we'd like to see the bill move forward.
Well, I never want to go sideways with you or with the Attorney General, so it sounds like we're on the right path here.
Right. So, Senator, did you want to present your bill, or? And I just also want to make sure that members had an opportunity to see the additional language. Senator, do you want to say anything about your bill?
Yeah, well, I think you pretty much know the intent of the bill, and of course the bill enables the Attorney General of Virginia to conduct the pattern and practices investigation of law enforcement agencies to identify and put a stop to unconstitutional practices such as patterns of excessive force, illegal searches, biased policing, or other unconstitutional practices. Now, trust me, this has nothing to do with what's going on in my life right now. I wanted to introduce this bill long before I got charged with 2 Class 6 felonies. But I think this bill I think the additional language will go a long way to help strengthen the bill. And talking to the AG, the bill will authorize him to inquire into or seek to conciliate through a lawsuit whenever the Attorney General has reasonable cause to believe that law enforcement officers, agencies are engaging in patterns of practices that deprive persons of their rights, privileges, and immunities. And so I'd like very much for the bill to go forward in that form.
Then, Madam Chair, unless there are people wishing to speak on the amendments, I would move the
Are we
amendment.
frozen?
Madam Chair, this is Taylor. If the committee wanted to keep that language, it is already in the Senate bill, so you would not want to adopt the amendment that's been posted. That was striking the language.
Okay. So, Delegate Mullen?
I would withdraw my motion then.
All right.
Madam Chair,
Yes.
just a point of order, so I understand. So I saw there was an amendment put on the bill in the Senate. It put on Delegate Lopez's bill in the Senate. So just so I'm clear, if we do nothing to the bill currently before us, that is not take out this sentence, will it match what's currently before the Appropriations Committee in the Senate? Are they the same bill now?
Madam Chair, that would be correct. The amendment that they added to Delegate Lopez's bill, his bill is now identical to Senator Lucas's bill as is.
Thank you, Ms. May. Thank you, Ms. May. I appreciate it.
Thank you. So,
Madam Chair.
yes, Delegate Scott.
Well, in that case, I don't know, at the appropriate time, I'd like to move and report or move and refer to appropriations or whatever.
All right, it's been motioned by you. Is there a second?
Second.
Oh, yes. Okay. Members ready to vote, please do so electronic voting board.
Delegate Lindsay,
Delegate Lindsay is a yes.
Delegate Lindsay votes yes. Delegate Horn, Delegate Campbell, Delegate Miyares.
All right, the bill reports 13-6. Right, next is Senate Bill 5029, Senator Lucas again. This is the marijuana and certain traffic infractions, possession, issuing citations.
Yes.
My understanding there is a substitute.
Move the substitute.
And it tailors the substitute.
Yes.
Madam Chair, I've just posted it, so it may take a minute, but it would be a new substitute that would change the secondary offense language throughout the bill to prohibit a law enforcement officer from stopping a motor vehicle or pedestrian, et cetera. The previous language in Delegate Hope's bill, as this committee heard it, prohibited law enforcement officers from issuing citations unless the officer issuing such a citation had cause to stop or arrest the driver for another violation of the code or local ordinance. It also does include an additional exception for airports as far as prohibiting law enforcement officers from stopping, searching, or seizing a person on the basis of odor of marijuana. This substitute would make it identical to the substitute of Delegate Hope's HB 5058 that reported out of Senate Judiciary.
That is correct, Madam Chair.
All right, well, thank you. Well, the bill's before us, and I just make sure members had an opportunity to see the substitute.
I was quick on the gun, but I will move the substitute at this time.
All right, it's been motioned. Is there a second?
Second.
It's been motioned and second to adopt the substitute. All in favor, say aye.
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 Any opposed? All right, substitute is before us.
Move to report the substitute.
Second.
Hold on, actually, there's been a motion and substitute to report the substitute. There are members of the public who would like to speak on this. There's actually one. So we'll hear from the public and then we'll vote.
Hello?
Hi, Ms. Worth.
Hi. Yes, thank you.
Hi, thank you.
This opportunity to speak on this bill, and everything seems to be working fine. I guess we're all safe. I think that this is a great bill. I want to thank Senator Lucas. What this bill will do, I think, in a roundabout way, is prevent lots of opportunities for things to go wrong. When an officer pulls somebody over, maybe suspecting marijuana use alone, it seems like with everything that's going on, that's just sort of unnecessary. And we don't want to have unnecessary encounters between citizens and police officers, because there are, as I said, so many opportunities for things to go wrong. In this day and age, we want to be extremely careful about that. And we also want to prevent any opportunity for officer bias. And this can go two ways. There can also be, when a citizen stopped and he perhaps feels that he might be targeted in some way. This is a bias that can be on the part of the citizen as well. Everybody can be extremely nervous, and under those circumstances, there's a lot of things that can go wrong. So I think that this would be a great bill to prevent bad things from happening. And since I don't think we're going to be enforcing a whole lot of marijuana possession anymore, and so this would be a great bill. And I want to thank Senator Lucas again for introducing it. So speaking for Virginians Against Drug Violence, we support this bill. And there's another bill that comes up a little later about prepaid, and I'm for that too. So thanks again. Yeah.
Thank you. I appreciate it. All right, so the bill is before us. It has been motioned and seconded that we report the bill. Members, please cast your vote on the electronic voting board, our tablet.
Delegate Lindsay.
Delegate Lindsay is a yes.
Delegate Lindsay is a yes. Delegate Campbell.
All right. The bill passes 13-7. Thank you so much, Senator Lucas. Appreciate it.
Thank you, Madam Chair, and members of the committee. Be safe because your health and safety is very important to me. Thank you so much.
Thank you.
Have a good evening.
Take care. Senator Luck is not with us yet, so I'm going to move on to SB 5033. Senator Serville, Court Authority in Criminal Cases, Prosecutorial Discretion to Dispose of Criminal Case. And I understand there is a substitute, and this is similar to HB 5062. Look at Mullen.
Madam Speaker, Madam Chair, once staff has been able to talk about what this substitute does, I'd like to be able to speak to the substitute.
Yes, Madam Chair, this is Taylor, and I just published it, so again, it may take a minute for this substitute to come up on LIS, but the substitute would kind of combine Delegate Mullen's HB 5062, so it would keep the language that this committee reported out, and it would also include the second part that is in Senator Serville's SB 5033, and that part is that would allow, provide that upon agreement of the Commonwealth and the defendant and trial court may defer proceedings, defer entry of a conviction order if none, or defer entry of a final order. So it kind of combines the two bills, and it should be popping up shortly.
Senator Serville is with us, so if you all don't mind, I'll just have him go ahead and talk about the bill, so you'll have time to look. Senator Serville, welcome.
Thank you, Madam Chairman. Can you hear me?
Yes, I can.
Great. Thank you. And appreciate your time today, and appreciate you all taking me a little early, and hopefully my next bill as well. Senate Bill 5033 is written, basically resolves two outstanding disputes that are going on out there in our courthouses. The first one has to do with, you all may have read that in Norfolk and in Arlington, they're having a dispute within the prosecutor's offices and the bench and about whether or not a prosecutor should be able to drop certain charges. And Delegate Mullen and I sort of had competing approaches, and we in talking with stakeholders kind of settled on his approach as being the one that would do the least changes to the underlying case law. And basically what his approach does is says that if a Commonwealth attorney wants to dismiss a case and the accused person is okay with that, the court has to grant that motion unless somebody can show there's some kind of either bribery going on or animus towards probably the victim, I guess, either race, racial, sexual orientation, gender, etc. And that basically would conform Virginia practice to the federal practice when it comes to motions to dismiss without prejudice and with prejudice. That's sort of how I see it. The second part of the bill has to do with deferred dispositions. And for those of you who don't practice law, there's been a couple cases that have come down in the last 10 years, which have changed what the law was in Virginia for as long as I've been practicing, and probably well before that. The cases were called the Stars case, and there's another one that just came down about 2 months ago called Jenkins. But they basically said that judges don't have discretion to continue a charge and dismiss it or reduce a charge, even with the agreement of the parties. And what this means is that if somebody enters a guilty plea, they end up getting convicted and there's no other choice. And basically what this does is this gives prosecutors the ability to put a person on a rehabilitation plan, do community service, mental health treatment, drug treatment, et cetera, and then work towards that carrot at the end of the stick. You know, in a year, 6 months, a year, 2 years, they could work towards either getting their charge reduced or just outright dismissed. But again, this proposal is only with the acquiescence of the prosecutors. The prosecutor would act as a gatekeeper on that. And this is similar to a bill that I've introduced in session, but a little bit different. With this one, I have yet to receive a single objection from a single stakeholder about it. And so I think the bill is, as it's currently written, resolves a lot of disputes in our courthouses. It'll give prosecutors the ability to resolve cases without having to plead everybody guilty to everything, and put convictions on everybody. It'll incentivize rehabilitation, and I think it's consistent with everything we're trying to do this session.
And Madam Chair,
Yes, Delegate Mullen.
I would like to thank Senator Surville for working with me and for many of the other stakeholders on this issue. I think this does the least disruption possible to the last 200 years worth of case law, but I also think that it returns the possibility of redemption to the hands of the Commonwealth's attorneys and the public defenders who are doing the work every day here in the Commonwealth. I think that this language, and I do want to correct the record, I believe, Ms. May, correct me if I'm wrong, but we have substituted out the word animus for prejudice or bias. Is that correct?
Madam Chair, that is correct. That is a change from the bill that House Court saw before. It changed the word animus to bias or prejudice.
And to explain that, we don't use the term animus regularly within the criminal code. Prejudice or bias is a broader term that we use much more regularly within the criminal code. And after suggestions from Ms. May and from Senator Surville and others, we decided to be able to use that instead. So I think that this bill is an improvement on mine. I think it offers a lot more discretion to prosecutors, public defenders, and judges, while also making sure that some of the problems that we've seen in Arlington, Fairfax, and Norfolk are corrected.
Right. So I think we need to, did we adopt the substitute? I'm sorry. No.
Okay, I would move the
Have
substitute.
time. I wanted people to have time to take a look at it. Okay.
Second.
On the substitute to adopt, is there a second?
Second.
So moved and seconded to adopt the substitute. The bill is before us.
Move to report to substitute.
Member of the public, thank you.
Second.
Thanks. Raman Fati.
Yes, hello, Madam Chair. How are you?
Hi, welcome. You have a minute?
Thank you. It's good to be here. I am here to speak in support of this bill as both in its original form and as amended. I agree with both Senator Surville and Delegate Mullen that this is a nearly ideal solution to the ongoing disagreements that we've had between the executive and the judicial branches. I was counsel of record in our petition for mandamus here in Norfolk. The language that the committee has considered as a substitute is language that was vetted by Virginia Progressive Prosecutors for Justice. We appreciated being able to see it, and we think that it will allow us to serve the law and to provide individualized outcomes. So we would ask that the adopt the bill. Thank you for hearing from us. And I'll say specifically that I know that Virginia Progressive Prosecutors for Justice is in support of the dismissal language. I can speak for the Commonwealth's attorneys of Fairfax and Norfolk specifically on the bill as a whole. That shouldn't be interpreted to be less approval for the whole thing. It simply is a matter of time. I hadn't talked personally with everybody, and I didn't want to stand up and talk for elected officials without confirming. But I know that we are in support of this work.
Thank you so much.
Thank you.
All right. We did have a motion and a second to report the bill. Let me see. All members wishing to vote, please do so on your voting tablet.
Delegate Lindsay. Delegate Levine,
Madam Clerk, Delegate Lindsay is a yes.
Delegate Lindsay is a yes.
All right. Thank you. The roll is closed. The bill reports 13-7. Delegate Serval has another bill that's in the third block, but we're going to go ahead because he has a family obligation. So Delegate Serval, SB 5032.
Thank you, Madam Chairman, and I appreciate you taking me a little early. As you noted, my daughter, the soccer player, blew out her knee a couple weekends ago, and we have to have her knee reconstructed, and I got to go meet with a doctor soon to talk about that. So appreciate you all taking me a little early on this one. This is the bill that restructures the assault on police officer statute a little bit. And first, I'm going to, I guess, walk the committee through the bill, and then I think there's a few people that want to speak to it. But the first thing I want to say is what this bill does not do. This bill does not defund the police. It doesn't grant anyone the right to assault anybody. It doesn't make it legal to inflict an injury on anybody. And it also doesn't change the law of malicious wounding of a law enforcement officer, which carries a 2-year mandatory minimum sentence in Virginia. The bill that's in front of you, the statute that's in front of you, the mandatory minimum for assaulting a law enforcement officer, that was only put in place in 1997 as part of a compromise to get a mandatory minimum sentence on hate crimes, which we actually repealed last session. It was Delegate Plum's bill. Our current situation, the way this statute currently operates, it mainly affects, from my perspective, has bad effects, is over-inclusive, hurts the most folks who are mentally ill, who have interactions with law enforcement, and also given that minorities tend to be overrepresented, given the way policing currently occurs, it tends to overly affect, I think, minority populations who tend to get charged with this a lot. Right now, a police officer, this is the only crime on the books, of all the crimes in our books that I'm aware of, where the same person is the victim, the lead investigator, the lead witness, and the charging police officer. And it's because of those conflicts of interest, you see this charge overused and from my perspective, often abused in order to leverage a situation. So the language, the bill basically is as amended now, is in front of you, basically does three things. Number one is it eliminates the 6-month mandatory minimum sentence of 6 months for a conviction for this. It does not eliminate the felony. Every single charge that's charged under this will start as a felony. Secondly, on lines 39 through 43, we basically here took a concept which is in our reckless driving statute. And if you look at 462869 of the code under improper driving, it has this concept of diminished culpability. And so under Senate Bill 5032, it says if any person charged where the degree of culpability is slight and the person either has diminished physical or mental capacity or pervasive developmental disorder, or there's no bodily injury, a judge or jury in their discretion can find a misdemeanor. And just so the committee is aware, the language in this statute, first of all, the diminished capacity, again, the degree of culpability is slight. That concept comes from our improper driving statute. The diminished physical or mental capacity comes from 51.5, 144 of the Code of Virginia, which has to do with our definition of adults with impairments. That's defined in the code if you want to see what that means. And then under diminished, then it says pervasive developmental disorder. That term is likewise defined in the code. If you look at 38.23, 3418.17, that is 2011 legislation passed by Delegate Tad Greason that granted insurance coverage to individuals with autism. That language is a term of art to refer to autistic individuals. So that term is likewise defined in the code. And under the statutory interpretation concept of in pari materia, that would mean that the courts would look to those different statutes to define this statute consistently with that, given we've used the same language elsewhere in the code to define these things. So if there's any concern about a lack of clarity about what the statute means, that's where that comes from. And then the third thing the bill does is if you turn to the end of the bill, this deals with the conflict of interest situation. And actually, this was a suggestion. It was a suggestion inspired by our own Colonel Pike of the Capitol Police And this says that before any charge, felony charge could be brought, a police officer, there has to be an investigation by an independent police officer, and the Commonwealth attorney has to sign off on the charge. Colonel Pike, in looking at this statute, noted that, at least in his experience, a lot of times these charges emanate when a police officer goes through a bad arrest and they're very angry about what happened. And he thought that perhaps if there was like a cooling off period, cooler heads might prevail and so many of these charges might not be brought, especially over very minor situations. And so that's the idea there, is you bring some other people into the investigation to say, do we really need to charge this as a felony? So that's basically what the bill does. And just a couple other things I want to note. First of all, there's been a lot of confusion about what an assault or an assault and battery means. A person can commit an assault without ever touching somebody. A person can commit an assault and battery by the most minor of touchings. However, it's actually pretty easy to get a malicious wounding charge. The Court of Appeals has approved malicious wounding for an officer being sucker punched, being hit even in a single blow. There was a malicious wounding conviction that was affirmed by the Court of Appeals over somebody who had a sore shoulder. A concussion counts. Any kind of scar can count. A loss of consciousness counts. And I can cite, if anybody has any questions, I have about 10 cases here I can cite you to for any of these concepts. But the seminal case was Luck v. Commonwealth, in which the Court of Appeals found that bodily injury basically means bodily hurt, any bodily hurt whatsoever, which means that if somebody has a serious bodily injury, any bodily hurt whatsoever, they're looking at felony malicious wounding, 2-year mandatory minimum. And if you attempt to do that, say like by throwing a brick, that's a 2-year mandatory minimum. That's not, this bill does not change that law. So we're basically talking about very minor situations. And the data from the Virginia State Police shows that there's about 1,900 officer-involved assaults every year. Their data shows that in 70% of those cases, there's no injury at all to the police officer. In 25% of those cases, there are minor injuries. Only 5% of the cases involve serious injuries. And so this, I think if this bill were to pass, I think you would see a reduction in the number of these charges being brought. You'd see a reduction in felony convictions. And I think you would, but you would still see some people obviously getting convicted. But I think this would bring this situation more into focus about what the conduct is. And I would just note that I put out a request to the bar for situations or scenarios where people thought this statute was abused. I received over 80 replies from both lawyers and Virginians around the Commonwealth. The one you're probably most familiar with is the assault by onion ring, where a woman had recently been released and police officers grabbed her, an onion ring flew and hit the police officer. She didn't throw it. The onion ring flew out of the container and hit the police officer. So the officer charged her with felony assault with a 6-month mandatory minimum. The Court of Appeals in Commonwealth v. Adams affirmed a conviction for a child in school who hit a police officer with a laser pointer, affirmed a 6-month mandatory minimum for that. Chief Justice Don Lemons actually dissented from it when he was in the Court of Appeals. There's also another case the Court of Appeals affirmed where somebody had their finger and they said pow in a car. The Court of Appeals affirmed a 6-month mandatory minimum for that. I have other situations where water fell on shoes. People got hit with pepper spray and they started spitting because they had pepper spray in their face, and the spit hit somebody's shoe. An SRO who got bumped by a student in school. This statute needs to change, and I would hope that it also, again, the other thing I mentioned is it also gets a lot of folks who have mental illness. I think you'll hear some testimony from some people in the public about that. I'm going to leave it to them because I think they're much better advocates to talk about their scenarios than I am. But this statute, I think it, as most mandatory minimums are, is over inclusive, and it needs to be refined.
Thank you, Senator. I think what I'm going to do is we'll turn to the public testimony, and I'm sure members certainly have questions. So we're going to go first with Mr. Wayne Huggins from the Virginia State Police.
Good morning, Madam Chair. Thank you very much for affording me the opportunity to speak to you all today. And I want to say a word to Senator Service, because he engaged with us early on as this bill was being drafted and allowed us to have input into it. And while there's much in this bill that we do not disagree with. The one thing that we do have a concern about is this: there is no bodily injury. A police officer has the ability to avoid being contacted, blocking a punch.
Mr. Huggins, I'm sorry to interrupt you.
Yes, ma'am.
So we missed some of your testimony. You froze up at, we are concerned about this point with no bodily injury. If you can continue from there.
Thank you, Madam Chair. The fact that there is no bodily injury does not mean that an assault was not attempted. Through our defensive tactics training, if we are able to say block a punch, somebody throws a punch at us, or somebody swings an object at us, and we were able to block it and not get injured, that person, in my opinion, should be as culpable as the person who does connect with a punch or a blunt force object. So that's the one part of this bill that still concerns us very much, is that this need for a bodily injury before this charge can be brought. And we would like to see that amended, or at least that wording taken out or changed. We had an incident just last week, you may be aware of, where a trooper was struck on Interstate 64. He was not fortunate enough to block it. Had I been fortunate enough to block it, he could make the charge. I couldn't make the charge. So we think that's action that needs to be improved upon. And thank you again for affording me the opportunity.
All right, absolutely. Thank you so much. Next is Teresa Champion.
Thank you, Madam Chairman. My name is
welcome.
Teresa. Thank you. I'm Teresa Champion with the Virginia Autism Project, and I'd like to speak in support of Senate Bill 5032 as amended. No one is advocating for attacks on law enforcement, and let's be clear about that. And to continue, to say that this is expanding that is damaging hyperbole for many families who hope that you hear their voices, the voices of the disabled, the voices that have been impacted negatively by this current law. Many individuals with disabilities do not have what is called purposeful control over their body. They have they can't control their motor responses, their fight or flight response. They have panic attacks. They have tics. My own son has a tic disorder where he spits constantly. That's assault under this current law. So, as we've stated, law enforcement, and by their own data, shows that the majority of these charges have no physical injuries. If law enforcement is attacked, there are other charges that can be brought, and those have been highlighted. Families with disabilities live in fear of calling when in crisis because of the charge that could result of a felony against their loved one.
10 seconds.
They lose social services, they lose many benefits, but the damage is done. So we're trapping families. In conclusion, we're trapping families between a lack of social services, a lack of medical care, and a judicial system that holds them responsible for actions they can't control. Thank you.
Thank you so much. Next is Julie McConnell.
Good afternoon. Thank you
Hi.
for allowing me to testify on this bill. I'm
Thank you.
testifying
You have
on behalf.
1 minute.
Thank you. I'm testifying on behalf of the VBA Commission on the Needs of Children. I'm also a law professor at the University of Richmond, and I run a clinic where we represent kids in court on these very types of cases. I've been a prosecutor and a defense attorney, so I'm speaking from both perspectives as well. I am in support of this bill. However, I'd like to see it go actually further with regard to children and actually exclude children completely from being charged under the statute. It's gratuitous and unnecessary. Anytime a police officer is assaulted, he can be, a charge can be brought under the assault statute. It's a statute. If it's a very serious injury, it can be brought under the malicious wounding statute. There's also resisting arrest and obstruction of justice. Plenty of ways to charge if there is any inappropriate conduct here in an arrest. But we don't need to make it a felony, particularly for kids. If they're 14 or over, that felony will follow them for life. So it's not
10
something that's
seconds.
just going to be on their juvenile record. I want to give you two quick examples. One is a 12-year-old client who had a mental health crisis. The family called for help. The response from police was to put her in handcuffs, hold her hands tightly behind her arms, so much so that she struggled to have her arms released. In the process, she was charged with 2 counts of felony assault of a police officer with no injuries to the officers. 12 years old, mental health crisis. A second, a child, 15, trying to go into his own home with his key in the door. Officer stopped him, wanted to get information from him. He didn't want to give his birth date. He gave his name and address, but because he wouldn't give his birth date, they actually started to arrest him. He tried to pull his arm away from the handcuffs, charged with felony assault of a police officer. So we're making a felony where there is no crime in many of these cases. No one is suggesting that it's all right to assault officers, but there are other ways to charge these offenses. And I'm very much in support of any effort to make this law inapplicable to children and to, of course, abolish the mandatory minimum. But I think we could go even further and make it not the presumption that this would be the charge in these situations, but instead that we would use other parts of the code. Thank you very much.
Thank you so much. James Abrinio, and I apologize if I mispronounced your name.
No problem. Thank you, Madam Chairwoman. So I want to thank everybody for giving me the opportunity. My name is James. I'm legislative liaison for National Alliance of Mental Illness of Northern Virginia. Our goal is really to help those suffering from mental illness as well as their families in the stigma. And we are here in support of SB 5032. We want to thank Senator Servell for these efforts. To be clear, we're nonpartisan. We're not Republican or Democrat. And we also support law enforcement. In fact, we team up with them working with crisis intervention training to help de-escalate circumstances, to help provide empathy when it comes to law enforcement interactions with individuals suffering from mental illness. As it stands, Senator Servell went through it very well, and Professor McConnell provided a great example. As it stands, there's no requirement of injury. There's no requirement of actual physical touching. In fact, a behavior and overact that causes fear is enough as the law stands. And my understanding is, I apologize.
Yeah, it's 10 seconds. Go ahead.
From my understanding, when people suffer from mental health crises, law enforcement are the ones that are called. And it's this low threshold of the law interacting with individuals suffering from crisis. It's really the recipe for disaster. And the example of a young kid trying to get handcuffed and all of a sudden there's 2 assault on law enforcement charges. I'm also a practicing attorney. I can tell you I've had that very similar circumstance dealing with adults. Senator Servell also mentioned about water flying on shoes. That was my case. So my concern is when we deal with such a low threshold and the inherent nature when it comes to mental health, mental illness, and mental crises, we're really setting it up a situation that's really just the worst of the worst situations. What it also does when somebody's facing now an assault on law enforcement officer charge and they're suffering from mental crisis, now we're focused on how do we avoid that mandatory jail sentence rather than how do we get this person care. If they end up getting convicted, now they're away from the care that they need because in jail, we know they're not getting the treatment they need for at least 6 months. Now they've got that felony conviction. And it's just the cycle that keeps increasing. And so you've had somebody that's already vulnerable, now even more vulnerable, and they lack the skill set, and then trying to re-enter the community. We're essentially setting up to where, it's impossible. As we know, people...
Ken, if you can wrap up.
So thank you so much. Again, I want to appreciate everybody's work here. I know you're away from your friends, family, and you're away from your jobs, but thank you for the effort. Again, on behalf of the National Alliance of Mental Illness of Northern Virginia, we support this bill, and we appreciate your consideration. Thank you so much.
Thank you so much. We have John Jones. What's next?
Good afternoon, Madam Chairman and members
Hi.
of the House Courts of Justice Committee.
Welcome. You have 1 minute. Go ahead.
Can you hear me okay? Yeah.
Yes, I was just telling you, you have 1 minute. Thank you.
Okay. And thank you so much. The Virginia Sheriff's Association, we appreciate working with Senator Servell early on And there are two elements in the bill that we appreciate. One is relating to the diminished capacity and the conflict at the end of the bill. The problem that we have with the bill is the change to eliminating the mandatory minimum of 6 months. We think that it sends the wrong message to our law enforcement officers at this time. I'm representing 9,124 deputy sheriffs and folks in sheriff's offices. And I know I've been getting a lot of calls from all over about this bill because they view it as a diminished support for law enforcement. So if you pull out and you should pull out the amount of the donut assault, and you put all of those in another category, then that's all the more reason to leave the penalty where it is for the more serious assaults. So we appreciate you hearing our concerns, and I'll be happy to answer any questions that you might have.
Thank you so much. Appreciate it. Next, we have Shannon Taylor.
Good afternoon, Madam Chair, and all the members of the committee.
Good afternoon.
Yes.
You have a minute. Welcome.
Yes. Thank you. Shannon Taylor, the Commonwealth Attorney for Henrico County. I'm speaking on behalf as the Commonwealth Attorney for Henrico. I'm also a member of the Virginia Progressive Prosecutors for Justice. My colleague, Amy Ashworth, and I spoke before the Senate committee back in July and reference this particular issue. I can tell you that VPPJ is definitely against the mandatory minimums, and I'd like to offer up some additional data. In Henrico County, between 2017 and April of 2020, out of 177 felony assaults, 164 were reduced. That is why I support Senator Servel's the removal of the mandatory minimum. As this body knows, as we've been talking about jail reform, any charges that carry mandatory time has a more likelihood that individual will be incarcerated, which seems kind of counterintuitive when we have 164 out of 177 cases being reduced to misdemeanors, why we would have that penalty. The next paragraph that's been added by Senator Servel with respect to the diminished capacity, I personally am very supportive of this matter, and I think as the entire body of the Assembly is working towards the recognition of intellectual and developmental disabilities, that this is the right thing to do, as well as the degree of culpability is slight. Prosecutors, we've handled that before. We can continue to handle the definition of that term. And then lastly, I'd like to speak to the additional provision regarding the consulting prosecutors before the charges being taken out. I do respect Senator Servel's information with regards to this. I am going to recognize that my colleagues and potentially law enforcement agencies in the rural jurisdictions, there may not be more than one individual responding to the scene, or my colleagues who are solo prosecutors. I just want to recognize the mechanics of how that might be implemented. Could be a little problematic for them, but obviously for a jurisdiction like Henrico, we would be more than able to handle that. And I, again, do respect what Senator Servel has pointed out as the difficulties. And again, I will also be available for questions afterwards. Thank you, Madam Chairman.
Thank you so much. All right, and I believe that concludes our public testimony on the bill. So I have members with hands up. I'm going to first turn to Delegate Bourne, and then Delegate Campbell will be next. Delegate Bourne.
Thank you, Madam Chair. Is the patron still with us?
I'm here. My internet keeps going in and out, but I'm here.
All right. Hi.
That's okay. You look great, Senator Servel. So
You too, Delegate. No birds today, I see.
Not yet. We're not talking about civilian review panel, so they don't like many other bills. You talked about the degree of culpability is slight, and that comes from, I think you said, our traffic code section. Is that right?
Yeah, it comes from
improper driving or something like that.
46.2/869. It was adopted in 1966, and it's been used since then.
Is that the only other place in the code that turn of phrase is found?
As far as I'm aware.
Gotcha. Thank you. And are there any other places in the code where we allow for diminished capacity? I think you referenced it's defined a couple other places, or at least one other place.
That I would, there's always the common law affirmative defenses of insanity. But in terms of a specific defense to a criminal charge that uses those words, or it's not even necessarily a defense, but no, I don't believe those words appear, either the diminished physical or mental capacity or the pervasive developmental disorder words appear anywhere else except for in the definition for the autism insurance and in 51.5144, which is defines an adult with an impairment.
And I guess my last question is, I know last year, and I don't know the exact code section site, but at least with respect to autism, there's already a change that we made last year, I think, to a deferred finding that's available for autism. And so my question really is couldn't your bill sort of be a worse result for those with autism than what they currently have available?
It could be a worse result if, but I believe that I'd have to go back and look at the SIS statute we adopted last session. I can't remember whether that requires the acquiescence of the Commonwealth or not. And so what this statute would provide at least a safety valve for a judge or jury if a Commonwealth attorney refused to stop prosecuting somebody who had autism, which I know has been a problem. There was the individual who, I forget his name now, but he used to like to hang outside of libraries, and a police officer confronted him because he was wearing a hoodie standing outside a library. And when he did, he jerked and hit the officer, and he ended up on like a 5-year journey, which resulted in Governor Northam eventually pardoning him because of all the consequences that flew from that. But the Commonwealth attorney kept going after him and after him and after him every single time. So this would provide a safety valve for a judge or a jury if the Commonwealth attorney was being over aggressive. And I don't remember whether or not that bill we passed last year allows a judge to do that deferral process over the objection of the prosecutor. So that's the best I can answer that right now.
Madam Chair, just one last question. Can you help me understand why we didn't make special provisions for children, as one of the witnesses said? And I asked that because that's part of my frame of reference for things like this. When I was on the school board, we would see lots of assault on SRO or even assaults on teachers where the situation would be 2 kids are fighting or something like that, and a kid just sort of tries to break away, and the teacher gets hit or something. No injury, very slight, but because of the student code of conducts, you've got to bring them for expulsion because of that charge. So I just wonder why children are not addressed in the bill.
Well,
Senator, I think, Senator, you're frozen. Hold on.
Second. Yeah.
Senator Servo, you're frozen. We're not, can barely hear you.
Can you hear me now?
Yes, we can now. So if you could start at the beginning of your response.
Yeah. So the first thing I said was because I didn't think of it. Number one, and number two, juvenile courts always have additional powers to defer and dismiss charges unlike adult cases. So it just wasn't on my radar. And most of the scenarios that I've been presented with involve adults, although I know one of the scenarios I was presented with involved a juvenile who hit an SRO while trying to leave a room. So this does happen in schools. And obviously the laser pointer case the Court of Appeals affirmed was also a juvenile. But I hadn't thought about it until I guess Miss McConnell raised it a second ago.
And I thank you, Madam Chair, for allowing me those few questions. And I don't know whether counsel for the committee can answer the question regarding the code section we updated or changed last year versus this, and how or if that could be a worse result for folks with autism.
Well, we'll hear from
Madam Chair.
Yes. Council.
To answer Delegate Bourne's question, the 192303.6, which is Senator Stewart's bill last year, in my estimation, would give you a worse result. It does not require the consent of the Commonwealth for the court to take the case under advisement, and it actually properly defines autism as well. This bill uses pervasive developmental disorder, which actually isn't a term used in the scientific community anymore. Shortly after the passing of 38.234.18.17, the DSM was updated to get rid of pervasive developmental disorder as a diagnosis. It's now all under autism spectrum disorder. So there may be people who wouldn't even fit under this definition because it's not a definition anymore. Under that statute in 38.2, it actually doesn't define pervasive developmental disorder. It defines autism spectrum disorder by saying it can be a pervasive developmental disorder and a number of other disorders that, again, under the DSM-5, which I believe was changed in 2012, doesn't exist anymore. So now we've got this term of art that's not a scientific term. And additionally, you're getting a misdemeanor out of this as opposed to what you could have the charge fully dismissed under 192303.6.
Okay. Thank you, Council. Let's see. I have Delegate Campbell and then Delegate Bell.
You need to unmute your microphone, Delegate Campbell.
Thank you, Madam Speaker. I'd like to speak to the bill.
Okay. Yes, you can go ahead and speak to the bill.
From the number of citizens who have spoken to me about this bill that are basically saying they're reducing to a misdemeanor for beating up a cop or punching a cop, I'm concerned that this bill in itself will basically declare open season on police officers. I think that the people in the community actually understand it to be reduced to a misdemeanor, and that is a problem. But in addition to that, this bill, like Wayne Huggins said, it troubles me that a police officer with good defensive tactics that can protect himself can have someone jump on him and try to fight him, and because he doesn't receive any type of physical harm or any permanent injury, that person can be charged with a misdemeanor and never spend a day in jail. So I'm concerned about this bill for those reasons. I just think it's bad for law enforcement and it sends the wrong message to the public. Thank you, Madam Speaker.
Thank you. Thank you so much. Delegate Bell.
Madam Chair, I have a couple of questions for staff.
Yes, please go ahead.
Okay. I was parsing the sentence that the patron referred to about diminished physical capacity or mental capacity, and it would appear that even if there was an injury, the offender would be eligible for the misdemeanor if, and it says, due to such person's diminished physical or mental capacity or pervasive developmental disorder. The patron referenced 51.5.144, but that seems to be a whole different definition. It talks about, further it says, to the extent that he needs counseling or supervisory assistance or assistance with activities, ... Is there a definition of diminished physical or mental capacity that would apply to this section?
Madam Chair?
Yes, Council.
Yeah. To answer the question, there is no definition. Diminished capacity is something that comes up a lot in case law because it has been continuously shot down as not a defense to crimes under the common law. We have the bright line common law insanity, but not diminished capacity. So if it doesn't get to the point where you don't appreciate right or wrong, or you, because of a mental disease or defect, you have an irresistible impulse, then there is no definition of anything below that because it's consistently been rejected by the courts over the years as evidence being admissible in types of cases to diminished culpability. The definition that Senator Serval referenced uses those words to define another word, which is adult with an impairment. And so it doesn't actually define diminished capacity. So if a court was looking at this, they would define it by using its general meaning under the English language, because it is not defined anywhere else or used anywhere else in the code. And I think it could, even though the case law says that intoxication couldn't be something, but physical couldn't be a diminished physical capacity. It's just in dicta. There's no legal definition that intoxication could not be a diminished physical incapacity or mental incapacity. So that could, I think, be included in this definition by some judges who would want to expand this as well. And so, and Delegate Bell's right, these are in the disjunctive. And so you either have no bodily injury, or you could cause very serious bodily injury, but maybe not to the point that without the intent to get you to a malicious wounding, and would be able to get a misdemeanor out of this because of the person's diminished physical mental capacity, which could be being drunk.
Madam Chair, could I have a follow-up?
I think Senator Serval, and then Delegate Bell has.
Can I just say that exact language is the exact kind of misinformation that needs to get clear. A serious bodily injury equals malicious wounding every single time. The word serious bodily injury should not appear in any discussion with this statute. A minor bodily injury or no bodily injury is what this bill is about. Just so we're clear about that. I agree with everything else counsel said.
Right. Thank you. It's Delegate Bell.
So, Madam Chair, another question for staff.
Yes.
So on that issue, the level of injury needed, is it not the case, and I'm looking at one of the cases that, I guess it's Williams, but it just says, to be guilty under malicious wounding, a person must intend to, quote, permanently, not merely temporarily harm another person. So that if we want to say that malicious wounding provides an alternate path, that would only be where the intent was to maim, disfigure, disable, or kill, which means to permanently, not temporarily harm, in this case, the police officer. Is that right?
Madam Chair, Delegate Bell, yes, serious bodily injury does not make a malicious wounding. The intent to commit a act that involves the intent to maim, disfigure, disable, or kill is one of the elements of malicious wounding. Bodily injury is also an element, but not serious bodily injury. Bodily injury can be a circumstance which could show an intent to have those to maim, disfigure, disable, or kill, the amount of bodily injury. But there are certain cases where there has been serious bodily injury and they've been found to be an assault and battery because they didn't have the intent. So really it's that intent that matters when talking about a malicious wounding, not the resulting bodily injury. That is a circumstance, but you have cases where bodily injury occurs and serious bodily injury occurs, but you don't find malicious or unlawful wounding because you can't prove the intent. A lot of those are cases that involve assaults with the bare fist. And the court has said you cannot presume the intent to maim, disfigure, disable, or kill with an assault with a bare fist, even though you can punch somebody once very hard and it would cause serious injury, including, I think, the case you cited, which is Williams, where the person lost an eye. And that was found to be assault or to not have the intent to maim, disfigure, disable, or kill.
Right. And I don't see anyone else.
Madam Chair.
Yes. Delegate.
Thank you, Madam Chair. I have a motion at the right time.
Right. We have Delegate Levine, if you can.
Thank you, Madam Chair. So sort of two things. One is the issue. I think that I want to thank the Senator for bringing this to us, and I want to thank the witnesses. I think they have, at least in my mind, overwhelmingly pointed out this is a big problem, and a big problem we have in our Commonwealth. The idea that someone could be grabbed in an onion ring, could hit a police officer, and that person has a mandatory minimum of 6 months is clearly wrong. And the other examples, the spitting and so forth. So I want to be very, very clear. This is a big problem that I strongly agree needs to be fixed. Full stop. Now the question is how to fix it. A number of people are raising issues, and I will fully admit that these detailed questions of criminal law are not my specialty. So I'm going to leave it to others to sort of figure out the best way how to fix it. My only point is that this is a big problem that needs to be fixed, and I hope that we will find some way to fix it. But how to fix it, I'm going to leave to others. Thank you, Madam Chair.
Delegate Hope. And then Delegate Bourne will be next.
Thank you, Madam Chair. I didn't expect to do this, but I noticed in listening to the testimony and some of the members that have raised some legitimate concerns about mandatory minimums and the lack of definition for diminished capacity. I am also concerned that the issue that doesn't raised is how we address children as well. Not the least of which I don't know if it's clear about what we just did this past session and how it deals with autism. And so I think that there's a number of issues that have been raised that give me some pause and concern. However, I have heard from folks that have testified, state police and sheriffs and the Commonwealth's attorney, who all have one thing in common, and that is that they don't seem to have any issues with the provisions in the bill starting on line 99, 19.2-9.2. I think if we're in a position, and I always like to try to save bills if we can, is to strike the language that, and I guess I'm offering this as an amendment, strike the language on line 39 through 43, unstrike the language on line 37 to 38. So it retains the mandatory minimum and strikes the language having to do with a person's diminished physical and mental capacity, because I do think that there's enough issues that have been raised. So what you're left with is just lines 99 through 104, which I think is the least that we can do. I don't know what effect that it would have, but if you're able to bring in another objective party to investigate, maybe speak to the officer, speak to the victim to find out what really happened, and maybe you could reduce the number of these types of incidents from occurring. So that would be my motion, to amend the bill in that way. Madam Chair.
Madam
Right.
Chair.
I don't hear a second. Yes, Servo, Senator.
I would just note, I think if you just struck lines 12 all the way through lines 98, that would accomplish the same thing. So just leave lines 99 through 104. That technically, I think that's the right thing to do. And I could tell the body, if that's what you guys do, I wouldn't request a committee a conference on this. I'd be fine with that if that's where the committee's headed.
Second.
All right, it's been motioned and seconded to adopt those amendments. Hold on.
Madam Chair,
Yes. Delegate
speaking
Bourne.
to the motion.
Yes.
Speaking to the motion.
Yes. Delegate.
I was just trying to pull up the language to follow along with Delegate Hope. And so I guess my first question is, where did we land on what are we amending? What are we doing?
So Delegate Hope, you're muted.
Sorry, Madam Chair,
Yes.
Delegate Bourne, what we're doing is, if you're looking at the language on lines 99 through 104, that's the bill. The rest of it, I'm deleting, and I do think that this is worth having an objective body like the Crime Commission taking a look at these big issues related to mandatory minimums, the diminished capacity, how this deals with kids with autism, and whether we should include children in this. And so I think this does gut the bill. I recognize that, but I always like to be in a posture, if there's a way that there's some good things about the bill that we can save, we should try to do that. And I think this is the least that we could do. But then take a hard look at how Senator Servo deals with assault and dealing with a mandatory minimum. I think that deserves a second shot to look at. So that's my amendment.
So just to be clear, for my feeble mind, it's we're just going to change this from a global amendment to assaulting a police officer, just saying that this provision with regard to juveniles applies. So
No, it's
like
juveniles and adults.
All right, so I'm going to we have a procedure. There was a motion and a second. We're gonna, unless there's another motion, we're gonna, this is just a voice vote, correct? All right. But
Madam Chairman,
yes.
I really need clarification. The patron just said that it applies to juveniles and adults. The language, as I read it, applies only to juveniles. What is the actual status of this language?
Can I make, Madam Chair, could I speak to it to make it clear?
Yes, Senator.
Thank you. So if you look at line 100, it says before any arrest indictment, and arrests and indictments refer to adults. Service of a petition in the case of a juvenile is a term of art relating to juveniles. So that's why that language is there. So an arrest or an indictment refers to adults. Service of a petition in the case of a juvenile is for a juvenile. So this language would apply to both adults and juveniles.
Thank you for the
Madam Chair. Madam Chair.
Yes, Delegate Bourne.
I have a substitute motion. I'd like to speak to that motion.
Yes, Delegate Bourne.
Madam Chair, I would move that we gently PBI this bill and have you send a letter to the Crime Commission to study this. I think the last 4 or 5 minutes of conversation coupled with the entire discussion lends itself to a more thorough and lengthy discussion and debate so that we get the words right. I have learned over the last several weeks that words, definitions, standards matter when we're talking about these very weighty issues. And so rather than trying to do something which I wholeheartedly support, especially addressing juveniles in a measure like this, needs to be done right. We need to get it right. I've heard lots of times that we vote on bills, not ideas. And so I'd like to get us to a place where we can vote on a great bill that eliminates the mandatory minimums, really captures the essence of what we all know is happening in these instances. And so I would, again, move that we gently PBI with a letter to the Crime Commission to study for an introduction of a bill in 2021.
Second. All right, it's been motioned and second that we PBI the bill and then a letter to the Crime Commission to study. I will let, okay, perfect. And then we have 2 minutes per side on that motion. If anyone wants to speak. All right. And actually Crime Commission study on this mandatory minimum can include this bill, specific bill, and the capacity exists at the Crime Commission to do it so it's ready for 2021. So is this is a recorded vote? Members ready to vote on the motion, please do so.
Delegate Lindsay.
Delegate Lindsay is a yes.
Delegate Lindsay is a yes. Delegate Campbell. Smith.
Right. Clerk can close the roll. 18 yay, 18 noes, 1 abstention. Thank you, Senator. Right, next is Senator Boysko. This is the prisoner's conditional release sentence credits. It's similar to Delegate Scott's bill. Similar, but different. Senator Boysko.
Sure. Madam Chairwoman and members of the committee, SB 5034 includes earned sentence credit as well as compassionate release for geriatric and terminally ill inmates. My bill is very similar to Delegate Scott's earned sentence credit bill, and it also encompasses the language in Senator Bell's bill 5018, which we'll be hearing a little bit later. Delegate Scott and I have been working collaboratively for several months on this bill and with a wide range of advocates who recognize that existing criminal justice system here in Virginia is very costly. You know, we spend $1 billion a year. on our outdated system, and we are focusing on punishment as opposed to rehabilitation. There is substantial evidence that our system is evidence of systemic racism at every step of the process, and this is an effort to reform our prison system. As you are aware, our prisons are filled disproportionately with Black and brown individuals. In Virginia, we know that Virginia is above the average in incarceration, and the United States is at the top of the industrialized nations in mass incarceration. 779 individuals per 100,000 Virginians are incarcerated here in Virginia. And as I said, we're spending over $1 billion annually on this system. We can instead look at what other states have done, other conservative states, in fact. 34 have more generous earned sentence credit programs than we do, including my home states of Alabama and Arkansas, which are more conservative than we are here in Virginia, as well as Oklahoma and Texas. These earned sentence credit programs save money, and they are safer in the long term for the public, and they are seeing reduced recidivism around the country. And Madam Chairwoman and committee members, I ask that you move this forward through the appropriations. Happy to take questions and look forward to the conversation. Thank you.
Thank you so much. We do have members of the public, and I will give each person a minute to speak, and then we'll take action on your bill. This is Jen Carter.
Thank you, Madam Chair and members of the committee, for allowing me to speak on this issue once again. My
Absolutely,
name is
you have 1 minute. Thank you.
I'm co-founder of the Humanization Project. We support this legislation. As the bills conform and go to conference, I want to encourage you to keep several parts of Senator Boysko's bill. As we've seen, especially during COVID, leaving discretion up to DOC clearly does not work. So specifically, please include Section C, ensuring a person's right to appeal a decision to change their earning level, as we're already seeing some COs are increasing petty charges in regard to this legislation even potentially passing. Section D is also important, providing for credits while serving time in the jail before being transferred to DOC. We see people stuck there for years sometimes. I also encourage you to keep the idea in Section 3 regarding a working group being convened, but specify that the makeup of that group be dictated to include some advocates for people behind bars, and specifically, hopefully, someone who has also formerly been incarcerated. Lastly, it's been kind of sad to watch folks come to fear-mongering, as we know that evidence and data indicate that this legislation should be for all people, and not including everyone only perpetuates the inequity already inherent in the system. But we are grateful for this step, and we look forward to continuing to work with all of you to expand it even further. I want to end by thanking Senator Boysko and Delegate Scott for their sincere efforts carrying these bills. And thank you, Madam Chair, for your work both here in this committee and in the Crime Commission on this issue. Thank you.
Thank you so much. I appreciate it. Next is Frances Ross.
Hi, Madam Chair. I want to thank everyone for hosting this and for allowing us to participate. And I just want to encourage everybody to maybe look at it, from a different angle and go back to the fact that, safer prisons do make for safer communities. You are not just releasing people. They have to earn it, and only those who earn it would receive it. So I encourage everybody to please vote yes and to keep all those sections in there that are needed for everyone. And I'm going to stop talking so you can get on. And thank you again for your time.
Thank you so much. Sean Winetta.
Good afternoon, Madam Speaker.
Hi, you have 1 minute. Welcome.
Thank you and members of the committee for allowing me to speak again. My name is Sean Winetta. I'm Legislative Liaison for the Humanization Project. I want to thank the committee and the patrons of the Earned Sentence Credit Expansion Bills for giving us a small step forward in prison reform. As I've stated to this committee over the past 5 weeks, I'm a returning citizen with a nonviolent property crime for which I was sentenced to 30 years in prison. I served over 16 years of that sentence in Virginia's prisons before earning clemency from Governor Northam. This bill would have had a tremendous positive impact on me if I was still incarcerated, and it'll impact thousands of men and women in jail and prison now and in the generation to come. Should consider or add to lines 101 to 104 of Senate Bill 5034 specifically the makeup of the implementation working group, and mandate that the working group also include advocates and formerly incarcerated individuals, as we're critical stakeholders in this policy and its implementation. Simply leaving it to the Department of Corrections to deem who is actually a stakeholder is not appropriate, and frankly, it's irresponsible to leave it solely up to them. Amendments such as this would allow for greater transparency and accountability for the agency as well as this body, and many of us would appreciate if the committee would consider making this change. I firmly believe it does not go far enough, and I'm going to continue to advocate for further expansion on sentence credits. I look forward to working with you in the upcoming session in 2021.
Thank you so much. Angela Adenofi, and I apologize if I mispronounce your name.
Unmute your microphone.
Oops, sorry, I was muted.
That's all right. You have 1 minute. Welcome.
Thank you. Thank you, Madam Chair and members of the committee for the opportunity to speak. I support SB 5034, though I strongly believe more people should be eligible to earn additional sentence credits. The people behind our prison walls should not continue to be punished for the crimes in which they were convicted. Being eligible for enhanced earned sentence credits should be about how people are currently doing their time in regards to the individual's behavior and their commitment to rehabilitation. We have all made mistakes, but those mistakes do not define who we are. With that being said, the residents within the Virginia Department of Corrections should not be defined by their past lapses in judgment either. The focus should be on who they have become and their evolution during their time of incarceration. Forcing them to live in the past can be detrimental to their rehabilitation. However, allowing them to see that there is hope and giving them control over their future could make a world of difference when it comes to their release and the lives that these men and women will establish once they are released. Allowing all the people behind our prison walls to have an opportunity to pave their own future by earning time off their sentence and giving them a second chance can help break the cycle and put an end to stigmas that are likely to hinder their future progress, and in turn create safer communities and also keep them from returning to prison. Thank you, Madam Chair, for the opportunity.
Thank you so much. And next is Camille Cooper.
Good afternoon, Madam Chair. Thank you for the opportunity.
Good afternoon. Yeah, you have 1 minute.
1 minute. Members of the committee, I did send everyone an email with 2 statistical analysis reports from the Department of Corrections. I just want to highlight a few things from that report. On page 4 of the 2020 report, they do state that older offenders were more likely to have committed violent offenses than younger offenders, and the most common violent crime for older offenders was rape and sexual assault, which accounted for about 39% of the age 65 and older age group. During the Parole Review Commission, the Director of Corrections, Director Clark, in response to a question from me, did state that a large number of geriatrics are coming in as first-time offenders, and most are sex crime related. So I wanted to dispel a few myths about geriatric offenders and that commit sex offenses. They're a different type of offender than your robbery offender or drug offender. For these reasons, I would ask that all sex offenses be excluded from the geriatric provisions in both the BOISCO and the Bell bills. I don't know if you're going to conform those together, what that's going to look like in conference. And I would also ask that the earned credit provisions of the BOISCO bill be conformed to Delegate Scott's bill. I believe the number of his bill is 5148, but he can correct me if I'm wrong about that. I think that's the House bill that everybody worked on. And that's it. Thank you.
Thank you so much. All right, so the bill is before us. Is there a motion?
Madam Chair,
Yes, Delegate.
I would ask, if I might ask the patron a question.
Yes, Senator Voisko. Are you with us still?
I'm still here.
All right.
All right. Madam Chair, I'm trying to follow procedurally, have we conformed the language? Her bill has 2 parts. Have we conformed the second part to the Scott bill's language, or is that not happened?
Well, so we have not conformed the bill yet, and I would assume that in conforming, the geriatric release portion would be not there, so it would just be the earned sentence credit portion. But counsel, correct me, or if the clerk correct me if I'm wrong, that by conforming it to Delegate Scott's bill, we'll have just Delegate Scott's bill before us.
Madam Chair, this is Taylor May with Legislative
Yes.
Service. That is correct. If we conformed it to Delegate Scott's bill, it would remove those changes regarding conditional release. The committee could leave those provisions and just conform the portions dealing with the earned sentence credits if you'd like, but there's a substitute prepared that would conform it, but it would remove those changes to conditional release as well as conform the earned sentence credit portion.
So Delegate Bell, does that answer your question or?
Well, have we, I actually was just asking, have we conformed it? Has it been conformed?
We have not conformed. And Taylor,
Okay.
to make sure that I understand what I mean, this is just me. I would like to conform it to look exactly like Delegate Scott's bill. So is that the substitute?
So moved.
All right.
Second.
All right, so all in favor, it's been moved and seconded that the bill be conformed to Delegate Scott's. All in favor?
Aye.
Aye.
Any
Aye.
opposed? Okay, now we have a conformed bill in front of us, Delegate Bell.
All right, Madam Chair, so at this point is identical to Delegate Scott's bill as it left the floor, I guess. Is that right?
Madam Chair, that's correct. I just to publish it and it would be identical to the version that passed the House. There is one small technical change in the structure of the exclusions, but it doesn't change anything substantively.
Okay, ma'am, I have no questions of Delegate Scott's bill. Thank you.
Thank you so much. And it's coming, it's the substitutes up on LIS.
Madam Chair, it may just take a moment. It usually takes a couple minutes, but it has been.
So if a member wants to make a motion right now.
Move to report the substitute.
Second.
And refer.
And refer, yes.
Second.
The moved and seconded that we report and refer the substitute to appropriations. All members wishing to vote do so on the electronic voting board.
Delegate Lindsay.
Delegate Lindsay is a yes.
Delegate Lindsay is a yes. Delegate Campbell.
All right. The bill's reported 12-8. This substitute's reported. Thank you so much, Senator. Appreciate it.
Thank you all so much. I appreciate and good to see everybody. Y'all have a good day.
See you. All right. I'm going to go back up to Senator Locke's bill. This is the omnibus bill that includes Senate Bill 5030. And this bill has the elements of 10 separate House bills. Madam Clerk, I'll just read them for the members. This is Senator Locke's bill, Senate Bill 5030, Policing Reform, Acquisition of Military Property, Training of Officers, and De-escalation Techniques. It is similar to House Bills 5029, 5045, 5049, 5051, 5069, 5104, 5108, 5109, and 5112.
Madam Chairman?
Yes.
Does this also have HB 5099 in it? I don't think I heard you read that one on no-knock warrants.
I did not, but I'm almost certain it does. So it's not on the list by the clerk, but I know it does because I reviewed it just.
Yes, you only read 9 bill numbers.
Yeah. Let's confirm though. 59.
Madam Chair, it does include Delegate Aird's no-knock warrant bill.
All right.
So, Madam Chairman, if it's appropriate, I think just to get us started, I know that you and the senator are having conversations about how to synthesize the House and Senate approach on a number of these bills, and that's ongoing and hopefully productive. Just to keep everything moving along, though, in the right posture, I think what we need to do on our side would be to have adopt a substitute that incorporates the House language wherever it overlaps from House Bills 5029, 5045, 5049, 5051, 5069, 5099, 5104, 5108, 5109, and there was one other that you read. 5112, I guess.
Yes, 5112.
So I would move that we adopt a substitute that conforms those 10 bills into Senator Locke's.
Second.
Moved and seconded that the Senator Locke's bill be conformed to those House bills that were listed, the 10 House bills.
Madam Chair.
Yes. Delegate Mullen.
Madam Chair, Senator Locke lives about 7 miles down the street from me, and I just want to make sure that I'm not going to be doing anything that gets me in trouble.
You probably are, but that's okay.
Yeah, I saw her look. Uh-oh. Right.
I know where you live, Delegate.
Right. So, I guess, was there a motion? I apologize, y'all.
I moved to do that. I think
I seconded.
All right. So,
I live far away from Senator Locke, so I can make the motion.
Do members have any questions? Any questions from anybody? All right. So, all members wishing to vote.
Madam Chair.
Yes.
This is Taylor Mayer, Legislative Services. I did just publish a substitute that does change all of the parts of Senator Locke's bill that have a related House companion bill. All of those parts have been changed to be identical to the House versions of the bills. I will note that there are some portions of SB 5030 that did not have a companion House bill that are included in the substitute. If you would like me to note what parts those are. Or
yes, please note, please.
To remove them if you'd like. So SB 5030 also expanded the required law enforcement data collection for motor vehicle stops to include all investigatory motor vehicle stops, all stop and frisks based on reasonable suspicion, and all investigatory detentions that don't result in arrest or summons. This was related to Delegate Torian's Community Policing Act from last year, so it expands the data collection for that. The code sections that are affected would be 15.2, 1609, 10, 15.2, 1722.1, 52, 30.2, 5230.3, and 5230.4. And once the substitute pulls up, those are included in the substitute as of right now. So you should be able to see those. The next part is that Senate Bill 5030 also provided that any locality that failed or refused to report that required data from the Community Policing Act to the Department of State Police would be ineligible for 599 funding in the succeeding fiscal year. The code section affected by that would be 9.1168. So that's included in the substitute that will be published as of right now. There's also an enactment clause stating that those provisions requiring data collection and that elimination of funding wouldn't become effective until July 1st, 2021. Also, there is a portion in that same 9.1160 code section included in the substitute that any locality that does not have an accredited law enforcement agency shall be ineligible for an increase in 599 funding in the succeeding fiscal year. And this provision would become effective on July 1st, 2024. Also, it has some amendments made to section 19.2201 that would require every chief police officer defined in the bill to provide the attorney for the Commonwealth access to all records related to wrongful arrest or use of force complaints or other complaints that a person has been deprived of the rights, privileges, or immunities secured or protected by the laws of the United States and the Commonwealth made against a law enforcement officer that is employed by such chief police officer's agency when that law enforcement officer has a matter before the court. Also, SB 5030 created a new chapter in Title 19.2, which is numbered Chapter 7.1, that consists of sections 19.2, 83.3 through 19.2, 83.6. That whole chapter has additional provisions dealing with when a law enforcement officer it says states when they shall not use deadly force against a person, and it lays out some exceptions for when an officer may use deadly force against another person. And it also bans law enforcement officers from willfully discharging a firearm into or at a moving vehicle. And that part would be in the new section 19.2, 83.4 in the substitute. So none of those provisions had corresponding House bills. They're in the substitute as of right now, but if the committee wants to remove any of them, we can do that.
Thank you so much. What's the will of the committee?
So, Madam Chair, I think that Delegate Simon, so the motion, and I understand that after we adopt this substitute, that the appropriate motion on the whole bill would be to report and refer to appropriations. And I know that you again and Senator Locke are working, just like they're working over on the Senate side on trying to synthesize the House and Senate approach to a number of these issues. So I would hope there'd be the pleasure of the committee to adopt the substitute now so that we can keep that conversation going. And hopefully by the time these things reach the floor, we will be able to work out all of our differences on both sides and move forward with some consensus on these things.
All right, so the substitute has been adopted and there's a motion to report the substitute and refer to appropriations. Is there a second?
Second.
All right, it's been motioned and seconded. If members wishing to vote, do so on your electronic voting tablet.
Delegate Lindsay,
Delegate Lindsay is a yes.
Delegate Lindsay is a yes. Delegate Campbell of Smith,
Right, the bill's the substitute is, I'm sorry, reported 13-7 to appropriations. Thank you, Senator Locke.
This was an easy meeting to attend.
Yes, welcome.
Thank you.
All right, take care. Next is Senator Deeds, Senate Bill 5043. He left. Okay, so if there's no objection by the members, I will. Senator Deeds' bill is narrow and more narrow in scope than my expungement bill. There's a in the bill. He and I talked, and we would like to put the bills in conference, the expungement bills. So that is yes.
I move we conform Senator Deeds' bills to your bill, Madam Chair.
Second.
Right, it's been motion second that Senator Deeds' bill, SB 5043, is conformed to HB 5146. And seconded, all members wishing to vote, please do so. Oh, do we? I'm like,
say aye on the conforming.
Okay, and it needs to go to appropriations. Delegate Levine. So do you amend your motion?
So my motion, first of all, is to conform. So I'd like to vote on that.
And I think we need to conform, and then we can make a motion to send to appropriation.
All right. All in favor of conforming, say aye.
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 Any opposed? All right. The bill's conformed. What's the motion?
Now, Madam Chair, I move to report and refer the bill to appropriations.
Second.
It's been moved and seconded that the bill be reported and referred to appropriations. All members wishing to vote, please do so on your voting tablet.
Again, it's report as amended.
Delegate Lindsay,
Delegate Lindsay is a yes.
Delegate Lindsay is a yes. Delegate Miyares, Delegate Campbell of Smith.
Thank you, everybody. All right, and next on this block is Senator Marsden's bill, which is similar, or actually, I think it's my understanding is exactly the same. And Taylor, you correct me if I'm wrong. To House Bill 5059 by Delegate Willett. This is the hospice, certain home care organizations, immunity from civil liability COVID-19.
Madam Chair, it is identical.
All right, and it does not have to go to appropriations. Are there?
Madam Chair, unless there are any speakers in the queue, I move.
There are two people scheduled to speak, so we will call on Scott Johnson. He is not in the room. Mindy Carlin.
Hi there. Sorry, I just got connected. Can you hear me?
Welcome.
Yep. I know this bill is Thank you, Madam Chairman, members of the committee. I'm Mindy Carlin. I represent the Virginia Association of Community-Based Providers. We strongly support Delegate Willett's bill, and we support this bill as well. Thank you.
Thank you so much.
Madam Chair, this is Scott Johnson. They just let me in the room, and I would do that. Thank you.
Thank you so much.
Move to report.
Second.
All right, it's been moved and seconded that Senate Bill 5082 be reported. All members wishing to vote, please do so.
Delegate Lindsay.
Delegate Lindsay is a yes.
Delegate Campbell Smith.
Right. All right, the bill is reported 17-3. All right, next we'll turn to Senator Morrissey's Bill 5007, Criminal Cases Sentencing Reform. Right, so Senator is not here. We'll move on to Senator Stewart. Marijuana possession violations by adult shall be prepayable. Senator, welcome.
Thank you, Madam Chair. Can you hear me?
I can hear you.
Thank you, Madam Chair, members of the committee. Senate Bill 5013 very simply just allows folks who receive a simple possession of marijuana charge to prepay that offense. And I think that was Senator Evans' original intent, although for some reason that it wasn't accomplished. And so for those of us folks who actually practice in court, we're seeing these folks come in now having to have their cases adjudicated on a $25 civil fine. So this puts it in the process to allow the district courts committee to develop a form so that they can prepay the offense and not have to come to court.
Right, so Delegate, yes, thank you, Senator Stewart. And Senator Stewart, I carried it in the House as well. I told you, and I think we addressed it in the summons section of the bill, but I see this as a code cleanup, and I'm happy to support it. Delegate Mullen?
Madam Chair, I know that this was the intention of the chair as well. We don't usually like to be able to clean up things for judges who have gone awry, but I think Senator Stewart is correct that we can always be able to be more clear here in the General Assembly. So I would move at this time that this bill be reported.
Right, and I think we have.
Second.
Right, it's been moved and seconded the bill be reported. We do have someone from the public. Ramin Fatih, welcome.
Hello, everyone. Good to see you again. I am glad to see that everybody sees this as an administrative fix. We in the Norfolk Commonwealth's Attorney's Office are in full support. Thank you for hearing from me.
Thank you so much. All right. It's been motion and seconded that the bill be reported. All members wishing to vote do so on the electronic voting board.
Delegate Simon. Delegate Lindsay.
Delegate Lindsay is a yes.
Delegate Lindsay. Delegate Campbell.
All right. The bill passes 13-7. Thank you so much, Senator.
Thank you, Madam Chair, members of the committee.
All right, thanks. Now, Senator Morrissey is here. Welcome, Senator Morrissey.
Hi, how is everybody?
Good. Good. Welcome.
All right. Thank you, Madam Chair, for allowing me to present my bill. It's generically known as the jury trial but judge sentencing bill. I think everybody is familiar with the bill, and the essence of it is that it allows, for those that aren't aware, the essence of the bill is that it allows a defendant to avail himself of the constitutional right of a jury trial, but then judge sentencing. 44 states have just that process. The federal system has just that process. I've talked to almost everybody that is a stakeholder in this, and the only point in opposition deals with the cost. It's going to cost too much money. We need to study this more. So, Madam Chair, with your blessing, let me get right to that cost issue right now. You may remember that this bill got a fair amount of robust debate when I presented it to the House during the 2020 session. And in there, I pointed out that I did not expect, after perhaps an initial uptick, for there to be any great demand in jury trials. And I gave the subcommittee a matrix showing all of those states that have jury trial judge sentencing. And it was interesting to note that 2 states, Connecticut and Nebraska, which have jury trial judge sentencing, have the lowest percentage rate of jury trial requests in the country. I thought that was significant. The other thing is, we all know the following, that this bill is going to overall reduce the number of net years for people in prison. Thereby, it's going to be a global saving. But some folks, particularly VACA, have said, and I'm quoting, it's going to increase jury demands by 600 to 800%. Now, let's just stop there for a moment. If that's the case, if that were to be true, which I will debunk in just a moment, then it proves my point that I've been making for a year, that this jury trial, jury sentence chills people's rights to jury trials. And let's be clear what's going on. The Commonwealth Attorney is saying, here is my offer. Take it or leave it. Let's say a case has a sentencing guidelines of 8 months to a year and a half. The offer is 3 years. The defendant rejects it, and the Commonwealth says, take a jury trial, which is code for jury sentencing. If VACA is correct and jury demands will go up, then it proves my point that we are having an overall chilling effect on jury trials. The other thing that and penultimate point, and then I'll try to answer some questions because I have a feeling that there may be a few, is this. There has been some suggestion that the juries, the citizenry, is being denied their right to participate. No, they're not. They are deciding guilt or innocence. But the one person who has the most tools at his or her disposal to sentence, the judge who has the sentencing guidelines, who knows the nuances of the system, who understands the facts of the case, is the person that's going to be sentencing. So the juries the citizenry definitely has an impact. And by the way, if we wanted the citizens to always have a right, then we would just ban bench trials, and nobody suggests that. The other thing that I want to mention is this. no, but the juries never have a right to suspend sentences. The judge does. And the reason that is done is because it's not only an important part of the process, but the judges understand sometimes it's important to hold time over somebody's head. Sometimes it warrants a reduction, suspending time. And also, let's be clear, even though judges can modify downwards a jury verdict, it is only exercised in 8.8% of the cases, and even then, there's only often a minimal, de minimis reduction in the jury sentence. So I'll share one little vignette with you because it's the most recent one in my mind, and then, Madam Chair, I'll take yours and any of the members' questions. And that's this. It's an example that repeats itself every single day in 133 jurisdictions in the Commonwealth. 9 years ago, a defendant got into an assault with a police officer. Police officer saw him there and realized he didn't appear in court earlier that week on a trespass charge. The officer was not dressed in police uniform, didn't have a badge, didn't have a gun, didn't have a police car. He had a young female explorer with him that he was going to show the ropes, who had an interest in criminal jurisprudence. The police officer goes up to the defendant and says, "You need to come with me because we have a capias out for you." He says, "Who are you? Who are you?" And they struggled. And he said, he had no idea who he was. The officer said, "Well, I've got a police car right down the road." Well, it was out of sight. They got into a struggle. The police officer sustained minor injuries, resulted in him getting 4 stitches. He was in the hospital for 2 hours. He was back on full duty the next day. Offer rejected. Jury trial, malicious wounding of police officer, 5 to 30. A offer of a de minimis sentence was rejected. Jury came back 26 years. Jury didn't suspend a day. A judge didn't suspend a day of it and said, he decided to have a jury. The jury spoke. I'm not gonna change that. Now, if you think that's an outlier, you are wrong. It happens every single day. So what I'm asking this panel to do is to pass this jury trial, judge sentencing, and it's the defendant has the option, judge or jury. With that, I'm going to stop, Madam Chair, and try to answer any questions.
I appreciate it. Thanks so much. Council had some few points and I think the committee, he shared with me. Steve Mutnick, I don't see you on my screen.
Yep, I'm still here.
There we are. Go ahead.
Madam Chair, the big issue that I wanted to bring up is with the first section, which actually doesn't have to do with the jury sentencing part of it, is the I guess it's probably the COVID fix we would call it, but I think it's unconstitutional. I don't think we can, in a statute, tell the Commonwealth something they can't do, that they have a constitutional right to. In Article 1, Section 2, withhold a jury. I understand what the senator is trying to do with this, and although I haven't seen it in my practice, I know that I've heard stories of it since the COVID crisis started, but I just don't think legally we can do it. It's not, you can't use a statute to overrule a constitutional provision. So that's my
are you talking about
that part of this bill?
Line 18, the attorney for the Commonwealth shall not.
And 18 through 21.
Yes, okay. Madam Chair, that's the provision, as everybody on the panel knows. A defendant opts for a trial. We've got to get concurrence of the court and the prosecutor. This particular section was inserted because, exactly as the delegate said, because of COVID-19. When there was a moratorium on juries, a demand for a jury trial necessitated continuing the case for literally months and months. 6, 8, 10, 12 months is the net result thus far. And so this would prevent the acquiescence of the Commonwealth concurring to or should not withhold his concurrence to a proceeding without a jury. And it's only for an emergency like we're seeing right now. With regard to the delegate's suggestion that it would not pass.
I'm sorry, he's our counsel.
Oh, I'm
He's
sorry.
our attorney.
I beg your
Sorry.
pardon, because your face on my screen is darkened and I can't see your name. I beg your pardon.
I'll take the promotion.
Okay.
That's okay. I'll try to get him out of the light.
When you say it will not pass constitutional muster, you're talking about state constitutional muster.
Yes, I'm talking about the Constitution, the Virginia Constitution in Article 1, Section 8 says that the Commonwealth has the right to concur. I understand totally what the point of it is. I think it needs to be done by constitutional amendment, not by statute.
Very well.
Because all this statute is repeating Article 1, Section 8.
All right. And Council, Steve, did you have something else?
The other issue, just on a story that he told, that one of the things, and I actually heard this a couple weeks ago and it made perfect sense, is that reforming all of this needs to be done in a huge way, because the story that you just told about the 5 to 30, we hear it all the time in drug cases, 5 to 40, that's what the General Assembly says. It should be 5 years. And that minimum 5 was passed way back when we had parole. And so everybody knew that wasn't the 5. And so I think having the jury sentence is not necessarily the problem. The problem is we have these minimums in our code that were passed back when we didn't have truth in sentencing. And another issue that I'll point out, and I think most people know, I'm a practicing criminal attorney. I do majority court-appointed work, and I do it in a jurisdiction that doesn't have a public defender's office. And I know, and I talk to a number of my colleagues in where, of course, we're going to start asking for juries. We're going to start asking for juries in almost every case that isn't just a slam dunk. And even in the slam dunk, you might as well give it a try. And I think it'll normalize after a while back to the point where it won't. But there'll be a few years where it doesn't do that. And I get paid $120 per misdemeanor and $445 per felony. If I do a jury trial, and I'll tell you, the felony is 5 hours of work. And that's how much the $90 an hour for $445 cap covers. 5 hours of work. The typical jury trial is at least a day, at least 8 hours of work. And that's just in court time. That's not prep time. There's waiver money available if I put in extra time, but I have to apply for that. And there's no more. Last year I got voucher back for $445 because the money had run out. And basically my issue that I want to point out is that without the money to pay the attorney, they won't be able to do this work anymore. And I enjoy doing the work. And so just my point would be, as a practicing attorney, and that's what the counsel of the courts committee is supposed to be, and provide to the committee, is there needs to be a much more bigger reform of all of these things to include this jury sentencing change as well.
Counsel, I appreciate
Madam
that
Chairman.
story, and I agree with you 100%, full stop. That's another bill, respectfully, for another day. And I've always felt that court-appointed attorneys and public defenders are not on equal parity with prosecutors. However, I'll also bring to your attention one of my favorite cases, Gideon versus Rainwhite, that was made into a movie, Gideon's Song. And in 1963, when that passed the United States Supreme Court, up until that point, indigent defendants were not entitled to an attorney, save a capital case. They went into court by themselves, and never. And at that time, we heard the same arguments. Oh, if we give everybody an attorney, isn't it going to cost the Commonwealth or the various sister states more money? Yes, it would. But what was far worse was having a defendant go up against an experienced prosecutor and be exposed to decades in jail without an attorney. So I agree with you, and I appreciate you bringing that to the panel's attention, that public defenders and court-appointed folk like yourself deserve more money. I have supported that since I came into the House of Delegates in 2008. That's not my bill, Counselor. My bill says this: if a defendant wants to avail himself of his United States and state constitutional right to a jury trial, he may do so while at the same time allowing the judge to sentence. And what is going to happen is there's going to be an uptick in a few cases. But let me tell you also, this is what's going to happen as well, Counselor. The Commonwealth Attorney, after getting deluged with jury requests, is then going to offer a plea bargain that's commensurate with the sentencing guidelines. And it's not going to take years, Counselor. It'll take months.
All right, we're going to go to public testimony, and then I've got a member who wants to speak. So Brad Haywood from Justice Forward.
Good afternoon.
Good afternoon. You have a minute. Welcome.
Thanks a lot. In addition to being the Executive Director of Justice Forward Virginia, I'm also the Chief Public Defender in Arlington County and the City of Falls Church. Senator Morrissey said a lot of what I was going to say. I agree with everything that he said. I would add, from the perspective of criminal defense practitioners, I would say that mandatory jury sentencing is probably the least fair aspect of Virginia criminal procedure. I think if you took a poll of 10 public defenders, 9, if not 10, would vote yes, that is probably the least fair aspect of Virginia criminal procedure. And it's not that we're actually one of 6 that still have jury sentencing. We're actually one of 2 states, one of only 2 states where jury sentencing is entirely mandatory. And the other one is Kentucky. So us in Kentucky, we're the only 2 states that still do this way. And it really is truly a matter of fundamental constitutional rights. Mandatory jury sentencing is a major factor, like Senator Morrissey argued, in a phenomenon known as the trial penalty. It's a huge reason, probably the primary reason that only 2% of felony convictions in Virginia, less than 2% of felony convictions in Virginia result from jury trials. The common law system, basically, if you're not having a meaningful number of trials, you don't have a fair system. We don't have a meaningful number of trials or jury trials in Virginia, and our system isn't fair as a result. As far as these cost arguments, totally agree with what Senator Morrissey was saying. I think, for one, there's this premise that if you take away a little bit of somebody's bargaining power, that no deals are going to be possible. That just doesn't make any sense. You're not going to have the same deals. The deals aren't going to be as punitive, but deals will be possible. It's just that prosecutors are going to need to start making better plea offers, and specifically in cases where the defendant has a real argument that he did not do it. Because if the person has no argument, the evidence is strong, there's no reason that you would ever adjust the offer that you make. Lastly, even if there was, is my time up?
You just wrap up, 10 seconds.
Oh, okay. Even if we're talking in Arlington County, I'll just give you some perspective. If we're talking an exponential increase, even an exponential increase, which I don't see as likely in jury trials, right now in Arlington County, there are 8 felony jury trials a year that result in convictions. Even if a third of them are acquittals, that's 12, maybe 15 juries in a whole year. And you're telling me that to preserve someone's fundamental rights, we can't have, 30, 40 juries a year? It's just, that argument doesn't hold water, and that's why we support SB 5007.
Thank you so much. All right, Maria Jankowski.
Thank you, Leader. Can you hear me?
Thank you. Yes, I can hear you. You have a minute. Thank you.
Thank you. Maria Jankowski, members of the committee, Virginia Indigent Defense Commission, and I do support this bill. Just a very brief background about myself. I have been a state public defender, a federal public defender. I have been a sole practitioner and worked in a small law firm doing exclusively criminal defense for over 25 years. And I'm going to respectfully disagree with counsel. I don't think lawyers are going to willy-nilly just ask for juries in every case. You're going to do your job. You are going to represent your client to the best of your ability. And let me agree with Senator Morrissey, and let me agree with Mr. Haywood. We may see a slight uptick in some very specific types of cases, but what we are going to see is an uptick in the cases where our clients are not guilty, where our clients are innocent, or where they have a credible claim of mitigation and innocence, or they've been grossly overcharged, which is incredibly common in our system. And if I can echo Senator Morrissey, these are the same arguments that we heard in opposition to Gideon. This is the same arguments we heard in opposition to giving people an attorney. Well, if you give them an attorney, they might actually fight their case. We have to see change. As Mr. Haywood said, this is unfair. We need a fair system, and that is all we are asking for, is a fair system. And once we have a more fair system, to credit Mr. Haywood, we will start seeing more reasonable resolutions. And to Senator Morrissey's point, it will be an incredible savings in the long run, because we won't have trial penalty sentences where somebody just got angry and decided to extract retribution. And when I say the somebody, I mean the prosecutor who was just mad and overcharged, and a jury's hands were bound and they were forced to impose a draconian sentence. That is what this bill fixes. It protects people with credible claims of innocence. It protects those who have been overcharged. And I believe it'll cause prosecutors to think about what they're charging and how they're charging. And we will have more reasonable and we will have more fair outcomes. Thank you, Madam Leader.
Thank you so much. Ramin is back again. Welcome.
Hello, everyone. Thanks for hearing from me for what I promise will be the final time today. Again, I'm Ramin Fadahi. I am a Deputy Commonwealth's Attorney here in Norfolk. I'm here to speak in support of Senator Morrissey's bill on behalf of Greg Underwood, the Norfolk Commonwealth's Attorney, Steve Toscano, the Fairfax Commonwealth's Attorney, and Parisa Dehakani Tafti, the Commonwealth's Attorney for the County of Arlington and City of Falls Church. I also have been a public defender, a federal prosecutor, and a state prosecutor. And if the committee will allow me, I'll speak from primarily a prosecutor's point of view in this case, on this bill. The fact of the matter is that the elected Commonwealth's attorneys on whose behalf I speak believe that the right to a trial by jury is a fundamental right. We also believe that in real world terms, despite the fact that the Supreme Court has found that our jury sentencing system is constitutional, that there is a chilling effect on the right of a defendant's trial by jury in having the various trial penalties that we have discussed. Now, I would disagree on a couple of minor points, none of which I would consider to lessen anybody's support for the bill that we really urge the committee to pass. First is the suggestion that the trial penalty is being applied uniformly across jurisdictions. Realistically speaking, I'm not going to say that we never demand juries here in Norfolk, but it is vanishingly rare, because the reality of the situation is that a jury in Norfolk is just as dangerous for a prosecutor as it is for a defense lawyer. It is not the sort of jurisdiction where a jury demand results in an automatic conviction. So the expectation that the offers in Norfolk would, for example, be significantly different following the abolition of jury sentencing, or the functional abolition of it, is probably not going to be the case. What it will do is free both the Commonwealth and the defense from the other side of the trial penalty, which is the sentencing ranges that everybody, including counsel from the courts committee, has discussed. Because even if we go into a case, agree to have a jury theoretically, and also agree that we're not going to insist on the ranges, a judge can overrule us. And the Sentencing Commission numbers show that judges overrule juries or suspend sentences very rarely, despite having the option to do that. So this is very much a situation where we want the defendant to be able to present his defense to a jury without concern that the jury's hands will be tied, and that we may not be in a position, we would be in a position to offer an opinion, but not necessarily to control the outcome. The question about...
You need to wrap up. I'm sorry. You're over time.
Oh, I apologize.
That's right.
I would simply say with cost, the length of juries is going to decrease even if the number of juries doesn't, or even if the number increase. So there will still be, the increase isn't going to be as dramatic. So any questions, I'm happy to answer. Thank you for your time.
Thank you. All right. Delegate Mullen.
Thank you, Madam Leader. Just speaking to the bill.
Yes, you have the floor, or the airwaves.
As it is. I want to first begin by telling Senator Morrissey that I appreciate all the work that he has done on this issue, and I think that he is correct. And I appreciate the amount of time that he spent with me prior to this special session, chatting with me and trying to be able to come to agreements on this issue. I also appreciate the earnest efforts made by so many on this to be able to change the criminal justice system here in Virginia for the better, and I certainly agree with the eventual outcome. I wish only to take a brief moment to be able to speak to some of the things that were brought up by the senator, by Mr. Fati, and by many others during this past hearing. I heard many in this hearing speak about how we don't vote on ideas, that we vote on bills. And I agree on that. It has been my opinion that I have not seen a bill with this potential fiscal impact statement of either negative or positive ever come through this body. We have routinely put a Woodrum amendment of $50,000 on bills that we pass, acknowledging the fact that our actions have financial consequences, not just consequences in the courtroom. And yet, today, we wish to be able to speculate in one direction, but not in the other. And I find that troubling, that we would speculate that this is going to have great cost savings, but no costs. That's not how we do business as the Virginia House of Delegates. I love this idea. I truly do. I love being in the courtroom. I love trying jury trials, and I think that the jury penalty is real. But even by the acquiescence of the patron, there will be some initial costs. And so what we have decided here today, if we were to pass this bill, is to just ignore that and pass that on to Norfolk, to pass that on to Richmond, to pass that on to Arlington and Alexandria and Newport News and everywhere else where they are going to have to pay. And I understand that there are constitutional rights that have no cost attributed to them, but I would want to speak to that as well, which is that there are constitutional rights for those who are currently incarcerated that will harm them. Everyone who is arrested has a right to a speedy trial. And I want to put that on a full stop. You have a right to a speedy trial under the Constitution of Virginia as well as the Constitution of the United States. You also have a statutory right to that. But if we grind this system to a halt, everyone who is in jail or prison right now will stay there for months, if not years. And maybe I'm wrong. I have no idea. But I can tell you this, no one in this body knows the answer. And so we want to balance the rights of those who are sitting in jail or prison right now against the rights of those who may be out but want to be able to have a better plea bargain. I don't know how to balance that, but I can tell you this, we have amazing people at the Crime Commission who have been tasked with coming up with this information by January. There's nothing that's happened between last January and today that changes anything. But I have full faith in the Appropriations Committee and the Finance Committees of both of these bodies to come up with a number and to pay for it. We have some of the lowest Indigent Defense Council payments in the country. And so you want somebody to be paid $140 to take multiple cases to juries? People won't do it. And then you will find yourselves without counsel in 100+ jurisdictions across the Commonwealth. Everyone's benefiting by having public defenders. We expanded that to Prince William County this year, and I hope that we can eventually get to that across the Commonwealth. But we don't have that. And we don't pass ideas, we pass bills. And if this ends up passing, there is a very good likelihood that people will remain in jail or prison for months, if not years, so that others may have a better plea bargain. And that's what this is about. This is about starving the beast, about saying that there is not enough money, so I'm going to offer a better plea agreement because I can't try enough cases as a prosecutor. And you know what? I am purely speculating right now. But everybody else in this committee right now is doing the same. And no one here has an answer. But I can tell you who does by January, and that's the Crime Commission. And they can put a number on this easily. But if we want to agree with the senator and others who have testified that this will save money, that's fine. Or if we want to agree with those who have testified otherwise that this will cost money, that's fine. But everyone here is speculating. And that is not the way that this body and this committee has done business for so long. And so today, I can't vote for this bill. But I can tell you this, that when there is an appropriations that comes from this, I will be the first to speak in favor of it. Thank you, Madam Chair.
Madam Chair, would it be appropriate to me to have a brief response?
Yes, if you want to right now, that would be fine if you're brief, yes.
Well, it's present in everybody's mind. You know, I'm a little bit older than some of the folks to whom I'm speaking right now. In the 1990s, I was the early 1990s, I was the Commonwealth Attorney in Richmond. We had 16 prosecutors in the busiest office in the state. Routinely, judges would do 60 jury trials a year. That was before we had bifurcated juries. And if there's any jurisdiction which is more likely to demand juries, it was Richmond, Virginia. I think we did at one point as much as a third of the jury trials in the states. Well, we also had 150, 160 murders a year. Now, crime in Richmond is down dramatically, 40 murders a year on average. Other crimes down dramatically. The number of prosecutors has gone from 16 to 36. So when when Delegate Mullen says that it is going to be a huge cost and will keep people in jail for months, if not years, I respectfully disagree. Delegate Mullen and I agree that the jury penalty is real. That means he agrees that people are not taking juries because of the jury penalty. And I got to say this, I don't know a single defense attorney out there, not one, public court appointed or public defender, that has ever considered dollars. I'm only getting $540 if I take this to a jury trial, who has said, just not going to do it. It's too little money. I'm going to plead him guilty. I am telling you with certitude that what will happen is that the plea agreements will be commensurate with the crime. And if we delay this matter, then we are saying we will delay or we will not allow people to avail themselves of the right to a jury trial because we're worried about cost. And I know 100 years ago, when we were talking about the constitutional right to vote, nobody said for women, you know what? This is going to cost more money for more registrars if we let women vote. This is going to be, we're going to need more money for the State Board of Election or its equivalent. And they simply said it's a violation of the Constitution. This existing experience where there is a admitted jury penalty is a denial of the constitutional right to a jury trial.
Thank you, Senator.
Thank you.
This Delegate Carol Foy.
Thank you, Madam Chair. Speaking to the bill.
Yes.
Thank you. As the first and only public defender ever elected to the General Assembly, I want to make clear that this is the most transformational bill we can pass to affect our criminal legal system. If we want a true justice system, we need for people to have full and unfettered access to a jury trial, with no threat of having only a jury sentencing when they have no access to a person's sentencing guidelines, sentencing memos, and other helpful tools to ensure fairness and equity. Now, we can talk about costs, but I'm talking about equity, fairness, and justice. We always find money to pay for our priorities. Well, what I'm saying is this must be a priority. You can't put a price on justice. It's as simple as that. We shouldn't deny people their constitutional rights out of fear of costs. We must stand in right. We must do what's right and not what's cheap and convenient. So I unequivocally support this bill. I thank the patron for bringing forth this bill. And I encourage everyone, if you really care about reforming our criminal justice system, if it's not just a token statement, then you will support this effort. And I encourage everyone to do the same. Thank you.
Thank you, Delegate. I have next Delegate Mieres.
Yeah, Madam Chair, permission to speak to the bill.
Absolutely. You have the floor.
Just both hearing the testimony and obviously we've heard a lot of people from the public that have testified as well. I think the thing that strikes me the most of hearing witness after witness in the testimony is the one word I'm never hearing from any of the testimony is victim. I don't hear that word. And I keep hearing about what is fairness and equity, and I don't understand the idea that if you're a victim of a rape, you can't get a jury to actually sentence your rapist unless your rapist gives you permission to. And I keep going back to the reason why we have jury sentencing in Virginia is this concept of the same jury of your peers that will determine your guilt or innocence should also determine your sentence. Because we have seen in a lot of cases where judges get it wrong. And I pointed out before the Brock Turner case, Stanford student, wealthy family, charged with 5 felony counts, accused of taking a woman behind a dumpster and raping her. Tried by a judge, sentenced by a judge. He served 90 days in jail. 90 days. And for the victim that went through that horror, what message sends that to her? Is that fair and equitable to the victim who doesn't recover in 90 days but have to live through that for the rest of her life? It doesn't. And so as we look at this bill, I think the patron noted that the goal of the bill was to reduce net years in prison. I appreciate the honesty, but I think all of us need to take into account the trauma the victims have gone through in these type of cases and remember the impact it has on them and that fact that we have the lowest recidivism rate of any state in the country. Some of that is the fact that you have jury sentencing. And so I would urge that my colleagues on the bill, as well-intentioned as this bill is, to vote no.
Thank you. Delegate Bourne.
Thank you, Madam Chair. Madam Chair, speaking to the bill.
Yes.
Madam Chair, we've considered a lot of very, very good bills this special session, in particular dealing with justice reform, police reform. There are a handful that are, as has been described by my colleague from Prince William, Delegate Carol Foy, that are transformational. This is one of those bills that is transformational. When you think about the justice system and who wields the most power, clearly a lot of things are out of whack. And while I appreciate and agree with the delegate from Virginia Beach by saying that judges get it wrong too, yes, they do. But what I would point out in response to that is not the point we should not focus on is that judges get it wrong, but it's the larger point that our justice system is broken. Black and brown defendants do not get a fair and equitable shake when they are being injected into the justice system. This proposal by Senator Morrissey will bring a greater level of fairness and equity, and allow people to get a shot at the fairness and equity. And so, while I believe there may be a cost, there may be some savings, both are probably right. I think this is important enough to move on so that we can get this policy in place as soon as possible and reform our justice system here in Virginia so that on this particular issue, we do not continue to be an outlier like we are today.
Great, thank you so much. Delegate Watts.
Thank you, Madam Chairman. Speaking to the bill.
Yes.
Let me start by addressing the Woodrum Amendment and looking behind the curtain of the Woodrum Amendment. The Woodrum Amendment projects out costs over a decade, over a 10-year period. It's not as if the token 50,000 or whatever number is put on it is an impact on an annual basis. It's always been in place, quite frankly, and I'm trying to remember whether or not it was put in place during my service or whether I came on board shortly after it. It was put on place, quite frankly, to put the brakes on the politics of being tough on crime. And by putting the Woodrum Amendment on, by putting some dollar figure on, the bill then had to go through a second scrutiny. Many times this has been good. But in this case, I am particularly concerned that it may be used to undercut our responsibility as the courts committee to address this serious issue of Virginia's jurisprudence and how we are so out of step with other states, and I believe with what the Constitution intends as far as jury trial. And the reason I say that is that there's another thing behind the curtain of the Woodrum Amendment, and that is because of the demands of the court's criminal law subcommittee, there has never been, I think in at least 3 decades and maybe more, any member who has served on the criminal law subcommittee also serving on appropriations. So we send these things up and there's no body of knowledge comparable to what there may be in healthcare or education or environment, you name it. That body of knowledge, often by the chair of the very committee, is represented on the discussion of Appropriations Committee, of the merits of the bill and whether this should have priority. We don't have that when it comes to criminal law bills that are sent based on the Woodrum Amendment. So returning to the fact that this, whatever number you choose to put on just to send it to appropriations with the hope perhaps that it can be killed that way, is just a numbers game. And at best, it's a projection over 10 years. Over that 10-year period, we will know what the effect will be on the kind of plea bargaining that this will even the playing field on, as is being discussed, as to whether or not someone believes that the full information about their sentencing will in fact take place when the sentence is in fact determined. It was appalling to me, quite frankly, in the last session when we discussed this, of how little information juries are given. And I simply could not understand why this is good judicial procedure. My final comment will be on the idea that you're entitled to a jury of your peers. Notice that, again, 44 states, or perhaps you'll say 48 states, with only Kentucky and Virginia being the outliers, have modified that concept that it's got to include sentencing as well as the determination of guilt or innocence. My memory says I dealt with this bill in my first term, way back when. I think it was a Republican senator, in fact, who brought it forth. And I puzzled about it as I'm trying to learn out of a fire hose. And I'm thinking, but wait a minute. Back in the day when we established this whole concept of a jury of your peers, the jury of your peers knew you as a person in the village, wherever you were. The jury in sentencing had knowledge that today's jury hasn't been given, both by design and by jury challenges, etc. And you're really operating blind, and the sentencing is not a sentence by a jury of your peers, as in the concept when this was first put into place literally centuries ago. It is time for us to face the reality that has been well expressed by those who have spoken to this bill, and I hope we will get a chance to have a vote on it.
Thank you so much, Delegate. Delegate Lindsay, and then we'll end with Delegate Scott.
Madam Chair, speaking to the measure.
Yes.
And just to give a little perspective as to where I come from in my remarks, I have formerly served as Chief Deputy Commonwealth Attorney for my city. I've been a substitute judge, was a substitute judge for 16 years, and I've been a member of the bar and doing a great deal of trial work in criminal litigation since 1984. And I'll tell you that my remarks far less focus on my history in the bar and focus more on my experiences, even most recently. I try cases, in different regions of the state. I recently was in a county, and the charge was possession with intent to distribute marijuana, not cocaine, not heroin, not PCP, marijuana, and a small amount at that. And we went to set the matter for trial, and the prosecutor said to me that it was going to have to be a jury trial. And I said, we're talking about the first offense of this nature, distribution of marijuana, and a small amount. And he said, yeah, I know, but my office's policy is that we set them for a jury trial, but don't worry. Yeah, I expect that you're going to get a reasonable offer from us before trial. All right, well, someone would say, well, that's an outlier because that's a county that's west of Suffolk. I'm not going to say how far west of Suffolk, but so let's go east of my city. The next city had a distribution case in Virginia Beach. The policy there also is that for all drug distribution cases, all drug cases, that these matters come before the court and are tried by jury. So if anyone is saying that this is about giving the victims their say, well, the victims never lose their say. That's what a trial is about. What it's about is it's about a system that is set up to punish those who are bold enough to take their chances at trial and to intimidate those who otherwise would want trial with knowing that there is a jury that they have to, try their case before, and that the jury doesn't have the awareness and wherewithal of a judge in terms of understanding this particular case in the grand scheme of all cases. And so it's very much favored to the prosecutor. I have a number of prosecutor friends, some of whom had hoped that I'd be among their ranks and had talked to me very candidly about this particular measure. And, and in those discussions, it was said, this is a tool that we have in our toolbox. No one's confused about, can a judge appreciate the facts and circumstances and render an appropriate verdict? But what they know is that to have a situation where a defendant is forced to either choose to try a case to a jury with all the risk that go with it, or to submit to a plea agreement that otherwise they might consider to be less than just. You're going to go with trying to minimize your exposure. In practice and in circumstance, what we have is a situation where the Commonwealth's Attorney's Office can make the decision as to whether a case has to be tried by a jury. That's all fine and good. And if this is about justice and if this is about fairness, then I have no problem with them continue to have that power. I just think that it's also appropriate that given that the judge has a full sense of this case by comparison to all others, and that a judge also has an appreciation for the sentencing guidelines, something that we're not permitted to give to the jurors, then let the judge have the ultimate say as to what an appropriate disposition is should a person be found guilty. Thank you, Madam Chair.
Thank you so much. Delegate Scott.
Thank you, Madam Chair. Speaking to the bill.
Yes.
Everybody has said a whole lot of things already. I don't want to repeat anything. I think, or try not to. It just seems striking to me when we start talking about issues that I know are going to impact Black and brown people. The first response we get almost every time is that it will cost too much. It really is offensive. It's sickening to see that we continue to say that we would rather continue to destroy lives, put people away, do economic harm to communities of color that we cannot recover from because it costs too much to do the right thing. That is what we say over and over, that it costs too much. We find reasons and ways to pay for all kinds of things, but we cannot figure out a way to pay for justice. As I listen to a lot of these bills, the first thing that I see in every bill, even my bill that I introduced and other people that introduce bills that would reduce prison sizes, the first thing we get back is that to reduce the prison size is going to cost you $17 million. Hold on, people are coming home. Hold on, I'm confused. Every single time we have a justice system that every research study shows that from arrest to policing to the court system to incarceration to release, post-release, is imbued with one quality: racism throughout the whole thing. And I know people say, oh, you're using a race card. I'm not using a race card. I'm using the data card. This is data that proves this. Okay. At the end of the day, we have a system whereby the most powerful person in this system is the police officer on the street, not the juror, not the judge, not even the Commonwealth attorney. It's the police officer. Then from there, it goes to the Commonwealth attorney, who has the most power to decide what he's going to charge or what type of things she would charge in this matter, and then how much power you have to take a plea or not. The risk in this thing, when we were doing course of justice last session, and we were looking at mitigating and aggravating factors and who sentenced, and we found that when judges sentenced, they did it within guidelines and they took into account mitigating factors, and they had much lower sentences. And we found that when jury sentence, because of they have a take it or leave it mentality, then the sentences are aggravated exponentially. And basically what we're saying is that to correct that unfairness, that bias that we know is baked into it, it's going to cost too much. So what we need to do right now is do another study and kick the can down the road. Well, I'm hopeful that we will vote to move this bill forward, and whatever the hell it costs, we need to fix it. we are not able right now to do any of the things that we all ran on, or at least I ran on, around criminal justice reform and police accountability. This is one of the steps that we need to take to make it. We couldn't do qualified immunity. We said it was too expensive. How the police officer going to pay for insurance? We can't increase earned citizen credit. We can't pay for it. We got to pay for more probation officers. And now we can't do more jury sentences because we don't know if we need more prosecutors or how we're going to pay the public defenders or the court appointed attorneys who may take these cases. We have to do something right now. This is it. I think this is a huge bill. I thank the Patriot for bringing it, and I'm going to wholeheartedly support it and continue to fight with him to get it passed. Thank you, Madam Chair.
Thank you so much, Delegate Scott. Delegate Mullen, you have something?
Yes, Chair. I just wanted to correct so that I'm a little bit more clear here. I'm not saying that this costs too much money. I'm saying that no one knows if it costs money or saves money, and that either way we should pay for it, and that we need to do this today. But no one here is saying how much it costs or how much it doesn't. And so I think that is a dangerous proposition when we pass a bill without knowing the cost.
Right. Senator Morrissey, anything you want to say before we take action? Oh, you're on mute. Oh, we can't hear you.
Can you hear me now, Madam Chair?
Yes, I can.
A lot has been said, and I'm not going to restate anything. I'm going to address one point. One of the delegates brought up the issue about nothing is being said about the victim. Victim it's the last 10 or so lines in the bill. The victim not only will testify at trial, be it jury or bench, but also the victim will always can avail himself of the victim impact statement. All the Commonwealth attorney has to do is ask for it, and the victim can address the judge at sentencing.
Thank you so much.
Thank you.
Right.
Madam Chair,
yes.
I have a motion.
Hold on, Delegate Scott. Yes, Delegate Scott.
I move to report and refer to appropriation.
Second.
Madam Chair. Moved in second. I hear a voice.
It's council.
Yes, council. Sorry.
Just wanted to reiterate the part about the first section lines 11 through 21 or 18 through 21 being unconstitutional, and wondering if the committee wants to do anything with that before we move the bill forward.
Madam Chairman.
Yes. Delegate Watts.
I move to amend the motion before us to strike lines 11 through 21. They do not affect the whole discussion that we've had on this bill. And again, they are in direct conflict with Article 1, Section 8.
Second.
Okay, it's been motion second that those lines 11 through 21, is that correct? Be stricken. Council, you're muted. Okay, that was correct. All in favor?
Aye. Aye.
Aye.
Opposed? All right. Now, Delegate Scott.
Yeah, now if the bill is in the correct posture, ma'am, I move to report. Madam Chair, I move to report and refer to appropriation. Thank you.
Okay, it's been motioned in Delegate Hope.
Second.
Seconds that the bill be reported and referred to appropriations. All members wishing to vote, please do so on the electronic voting board.
Delegate Lindsay.
Delegate Lindsay votes yes.
Delegate Lindsay votes yes. Delegate Campbell of Smith.
That's it. All right. So the bill is reporting forward 11-9. Right.
Thank you, Madam Chair. Thanks for your time.
Thank you. All right. Delegate Bell. Senator Bell, I'm sorry. So you.
I am here.
Senator Bell.
Hey, if Delegate Bell wants to present my bill and he's going to do a good job, I'm all right.
No. It looks. Senator Bell, welcome. I can't see it yet, but welcome.
My video shows it's running. I can hear you and I can see most of you, I think.
Right. Fantastic.
Would you like me to proceed?
Yes, go ahead, proceed.
Thank you, Madam Chair. First, this is a bill similar to what you've seen in years past. There have been some tweaks to it, and I'll go over those. This is known as the Compassionate Release Bill. And basically, it would create a mechanism for the Virginia Parole Board to consider, and that's a key point, consider release any offenders who are terminally ill. The current code actually allows this, but it only allows it at the 3 month diagnosis of terminally ill. 3 months is a pretty tough one because often what happens, first, it's hard to get the 3 month diagnosis correct. No offense to the medical community. It's, only God knows that. It's a tough one to thread the needle on. The other issue is paperwork often is in the system at some point, and in fact, the person will typically die before it actually gets processed. This would move that back to 12 months. This is based on a JAILARC study that actually recommended doing that. Also, the 12 months would be consistent with the federal criminal justice reform that was passed, signed into law by President Trump, the First Step Act. And this actually was designed to enhance efficiency and responsiveness of compassionate release with the Bureau of Prisons. This bill has changed a bit since it started. We've taken out the disability portion. There was some concern, which I agreed with, that someone could, frankly, have someone poke their eye out or do something to create a disability just to gain release. So we have taken that out. We also heard from a number of victims, and I'm very sensitive to that. And the last thing I want to do is do harm to victims who've already suffered. The bill excluded Class 1 felonies, which are the most heinous crimes. What we did is then exclude murder 1 and murder 2. There are some murders that actually fell into the Class 2 felonies, but we wanted to make sure that we exempted them as well. Again, out of caution. I will tell you that each one of these prisoners that's released saves the Commonwealth approximately $84,000 a year. So there's a significant savings. The care is difficult to care for the terminally ill behind bars. It often requires, if they go to a hospital, multiple correctional officers to escort, stay with them. It's a difficult thing. And frankly, as I've said in the past, I believe while we want justice, I think mercy is a key part of it. My hope is in alignment with that people who have done wrong would use those days to make amends with their family and perhaps those that they've harmed. And this release, I think, gives them the ability to do that in a more humane way. Again, I know you've heard this bill before. I'm happy to answer any questions. I will tell you the urgency related to COVID is anyone with a terminal diagnosis catches COVID behind bars, which is a high-risk environment, it's an immediate death sentence. So there is a connection to the current situation we're in. And with that, Madam Chair, I'm happy to answer any questions.
Great. I have no questions so far, so I do have.
Madam Chair?
Yes.
Delegate Sullivan.
Yes.
A question for the patron.
Madam Chair, please.
Madam Chair, question for the patron.
Yes. Yes, please go ahead.
Thank you, Madam Chair. Senator Bell, I love the terminally ill portion of this bill. I know that there's been some conversation about the geriatric portion of the bill. I wanted to give you a chance to address that. As I read this, someone who's 60 years old when they commit a crime will serve no more than 5 years of whatever sentence they got before being eligible for release. Is that right?
Madam Chair, that is correct. And I've spoken with Delegate Sullivan. I appreciate his concerns. And I am open to a friendly amendment if he so chooses.
Madam Chair, I do have such an amendment if this is the proper time.
This is proper time.
Madam Chair, I would suggest that we delete, be a line amendment, starting on line 15 after the word felony, after the comma after the word felony, would we delete everything else up through line 17 after Romanet 3. So that would make this truly a terminally ill bill, in my view.
Do I hear a second? That amendment?
Second.
Thank you. It's been moved and seconded. that amendment be made, taking out the geriatric release, and so we'll leave it no bill. All in favor?
Madam Chair,
Yes.
this is council.
Yes.
That's just lines 14 through 17 are just current law. That they all the changes that are made on there are just changing the code cleanups to be 65 written out instead of or 65 numerically instead of 65. But
Okay.
the 5 years and the 10 years are current law.
So,
Madam Chair?
yes, so we would have to do a substitute. Yes, delegate, Senator.
Yep, agreed. It is current code. My bill really just changed it from 3 months to 12 months. But this is definitely a concern that has been brought up through the debate. And I would defer to council, but I do believe it would have to be a substitute.
Right.
I'm actually not saying that that it needs to be an amendment or a substitute. It's just we are not taking out anything new in the bill. We're taking out current law that's been law since 1994. We're taking out what is currently geriatric parole by doing that, by deleting those lines.
Madam Chair,
I understand that, Madam Chair.
Madam Chair, question for council.
Yes.
If we take the offensive language, and I use that term loosely, out of this bill, that does not change the present law as it relates to geriatric release. It just doesn't speak to it in this bill. Am I right?
I think the point I'm making is that this bill doesn't change geriatric release at all. The only thing it changes is it numerically writes 65 instead of in words 65, and numerically writes 10 instead of using the word 10. Other than that, it doesn't change what's currently geriatric parole. It has been 5 years for somebody who's 65 years or older, or 10 years for somebody who's 60 or older, since at least 2001, if not 1994.
Madam Chairman?
Yes.
Question for council, but isn't there, the bill does make it that you shall be eligible as opposed to you may petition. And so it's automatically saying that if you reach that age, you are eligible. And I think there is a difference there. So I would rather have the existing law unchanged.
That I would agree. If on line 17, the two where it's crossed out and says may petition, I agree with Delegate Watts that is a change. I was pointing out that the other lines that everybody wanted to delete were not. They were just regular. So I think the appropriate would be an amendment to say that unstrike the words may petition.
Mm-hmm.
I make that motion, Madam Chair.
Madam Chair?
Yes.
It was my amendment, and I'm not sure I understand what council's suggesting. So could you, Mr. Mutnick, could you walk through that again?
Yes, Madam Chair, Delegate Sullivan. In order to restore this bill to what current law is on geriatric parole, we would have to keep the words on line 17 in may petition. And instead, and we not change any of the other strikes, because those are just code cleanup changes.
So this is the old adage, Sullivan, if you want to take out geriatric parole, get your own bill.
I think.
More or less. Yeah.
And there is a study going on parole, so that's what we're addressing. But so the motion is to unstrike may petition. Is there? I think I heard a second.
Madam Chair, just
yes.
Point of order, Madam Chair.
Yes.
My amendment was to do much more than that. So I either need to withdraw my motion, or Delegate Lindsay needs to broaden his. But the simpler way is probably for me to withdraw my motion.
Yes. All right.
And I apologize. I didn't think you had a second on your motion.
Okay.
All good. So now we're clean slate here. Delegate Lindsay, do you have a motion?
My motion is to, and now I've gotten confused. My motion is to amend the present measure so as to not impact the language that relates to what is presently the case for geriatric release, but only simply changes it to the may petition. Keep the may petition.
All right.
I think that's just simply on line 17, unstrike the words may and petition.
Right. That is correct.
That's the motion. I second it.
All right. So motion second to unstrike may petition on line 17. All in favor?
Madam Chair?
Yes.
I'm sure Mr. Mutnick will get this right, but don't we have to unstrike? No, I withdraw. I'm good. I withdraw my comment.
All right. So, okay, let's get through the motion. All in favor of unstriking?
Aye.
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 Any opposed? All right. So now the law, geriatric release is where it is, which is may petition. Thank you, Delegate Watts, for catching that. And then it would read that for terminally ill, which is 12 prognosis of a death within 12 months, would then also, the way it would read is eligible for consideration for parole, for conditional release. All right. And I don't see anyone in the queue yet. So what I'm going to do is I'm going to turn to public comment. Camille Cooper.
Madam Chair, I think that what just happened resolved my concerns with the bill, so I don't want to waste anyone's time, and I'll go ahead and withdraw my request to speak. Thank you.
Thank you so much. Appreciate it. Delegate Bell.
Madam Chair, I have a question. I'll direct it at the patron, but if what's happened is not clear, staff could answer. So I'm trying to track. The language would now say little Romanet 1, little Romanet 2 may petition, or little Romanet 3 is eligible for consideration by the parole board. Would they be petitioning, or the way it was drafted would say they're all eligible. The way it was current law, they say they may petition. This, I'm not sure it tracks. Does the language track? I'm not sure. Do they have to petition or not if it's under Romanet 3?
Madam Chair.
Yes.
If I may. First, my understanding, I'm not. We were supposed to have the assistant secretary online. I'm not sure if she's in the queue, perhaps, but my understanding is at a certain age, points 60 and 65, they automatically do reviews. But this would. I'm good getting rid of the may petition language, but I believe Miss Linda Bryan is on for any assistance. I'm not sure where she's at in the queue. She can answer that specifically. She might be the better answer on this.
We don't have her. We don't have anyone on from Department of Corrections.
Madam Chair.
Yes.
May I? If that was more just a technical, just trying to read it. May I ask the patron a question?
Sure. Yes, Delegate Bell.
Okay, Senator Bell. This would apply and make eligible if you were not part of the 2 excluded crimes. Anyone who had medical prognosis for the death within 12 months. If you committed the crime itself that had you imprisoned during those, basically, if you were already qualified as terminally ill and committed a crime, would you be eligible for consideration the way this is drafted?
Madam Chair, my understanding is yes, you would. Again, it would only be consideration. That would not guarantee that parole would be granted. And the key point would be the person would have to be deemed no risk to society. And I think that's a key point that has to be made here. But the bill certainly wasn't crafted with that in mind. But I can't say that could not happen.
Madam Chair, follow-up question.
Yes, Delegate. Yes.
Senator, I'm looking for the language about being no risk to society. Am I missing that? Is that somewhere here, or is that a defined term that I don't see?
Madam Chair, I'm reading through line 21. It's the Pro Board shall promulgate regulations, and their regulations actually currently already say no risk to society. So I misspoke on that. It's in their Pro Board regulations already.
All right.
Thank you.
Council, I think it's in terms of are eligible for consideration, would they not have to petition to be considered? And I'm wondering if we should say petition.
Madam Chair, I would defer to the Pro Board on their procedures, but I think under the statute, the Pro Board's not going to know they're terminally ill unless they bring it to their attention. And so I think it's a petition would be appropriate. So moving the words may petition to the end to apply to all 3 laminates is probably the safest way to do it, to make sure that people who are under this can bring that to the Parole Board's attention.
And Madam Chair?
Yes, Delegate Mullen.
So I am always in favor of belt and suspenders, but I would just note that I believe item 429 of the 220 budget already essentially got rid of the need for a petition process. We might be dealing with something that is relatively moot at this point, since this seems kind of academic. I'm totally in favor of it, but I think there are probably some budget language that has already sort of mooted this issue.
Okay. So I don't see what you're seeing. And so I'm going to be honest, I'm a little uneasy until I can see that language.
Chair, I will send that to you. And by the way, I'm absolutely okay with what we're doing. I'm just
right. Even if it's a floor fix, I'd rather that the language be consistent throughout the bill, because I feel like we're creating inconsistent. Maybe we can fix it on the floor if eligible is correct.
You have my complete approval.
I had all this in a study, but because it's before us now.
Madam Chair?
Yes.
I think based on what Council said, and frankly, based on what Delegate Bell said, that we just need to technically amend this to say, to take may petition out of line 17 and put it in place of is eligible for consideration by in line 19. And I think that would solve
That's your motion?
That is my motion, yes.
All right. Is there a second?
I guess I'll second them.
All right. It's been motion and second to move may petition to line 19, strikeout is eligible. Oh, for consideration.
For consideration by.
By.
And leave it stricken in line 17.
All right. All in favor of that motion?
Aye.
Aye.
Aye. Any opposed? All right. So that has been made. The bill's before us.
Move to report.
Madam Chair, I have my hand raised.
Oh, I'm sorry. Delegate Delaney.
Thank you, Madam Chair. I want to start by thanking the senator for bringing this back. I think that it is such a important issue that we're dealing with for people who are at such a sensitive end of life stage. To be able to find that mercy for them is certainly something that I support and want to continue to support this legislation. I do want to just raise the concern that, I appreciate that the delegate or the senator took into account the impact of victims of crime by and noting that in the legislation. And I recognize that, this could kind of open up that slippery slope of like, where do we draw the line when it comes to crimes against people where their impact is significant. But I do want to just make the case that, there are particularly violent and abhorrent crimes that, stay with that victim forever. and that the impact to them, is I think to many, having worked as a counselor, one that they would describe as possibly, worse than death. And I think that that's something that I want to be mindful of as we move forward, that if we're taking into account certain classes of felony and murder, that perhaps to also extend that thought to victims of other violent crimes as well, and to consider if that is something that we would like to discuss as a committee or moving forward.
Sorry, Delegate, is there an amendment you want to offer?
So, I mean, if it is the will of the committee, and if the patron, I know I spoke briefly with the patron about this concept, that if we had the opportunity to consider adding, in addition to the exemptions for the felonies and murder that is currently available or is currently in the bill as it's presented, to add some of the sex crimes that I know that we discussed in other legislation. I know that we kind of have, I guess, a list. And this is where I say it's kind of difficult. I would need to rely on council to maybe offer up to what point we would want to draw the line. But I think some of the more egregious types of sex offense and violent offense against that may want to be considered along with the carve out that is already in the bill. But I might need to ask council for a more specific proposal that I can then move as an amendment if the patron is open to that.
Oh, Senator, we can't hear you.
Sorry, can you hear me now?
Yes.
Yeah, I spoke with Delegate Delaney about this earlier. And, the last thing I want to do, while I want to do the merciful thing here, and obviously the thing that also I think is in the best interest of the Commonwealth, saves money, I don't want to cause harm to victims. And I do think we should be careful. I am open to a friendly amendment on violent offenders that aren't covered by Class 1, Class 2, or Class 1 felonies or Murder 1, Murder 2. But I do think the difficulty here, and we've experienced this in other bills, is where do you stop? Because the laundry list can become quite long, and then we have defeated, because the purpose of the bill, which was to let dying people out of jail. I again reiterate, the majority of these inmates who are terminally ill are bedridden. And that's a key point. However, having said that, I am sensitive to the concerns Delegate Delaney makes, and I would consider that a friendly amendment.
So, Delegate Delaney, I mean,
yeah, Madam Chair. I mean, I think if perhaps I could ask council for kind of a list of some of the crimes that I know that we've dealt with before when it comes to rape, object sexual penetration. We sort of have our list of, child offenses, some of the more egregious types of offenses that I think wouldn't necessarily be too far down the list from the ones that are already included in this bill that took into account that sensitivity to victims of crime.
Madam Chair, this is Steve Mudick. If we could start with the short list, which is the 19.2.297.1 list of violent crimes that includes murder, mob-related felonies, kidnapping and abduction, malicious felonious assaults, robbery and carjacking, criminal sexual assaults, contact offenses, arson when the structure was burned and occupied. That's the shortest list. The longer list to include all the other child-related crimes is probably analogous to the list that's included in Delegate Scott's earned sentence credit bill. But that's at this point down to a almost 18 or even more than that, probably 25, 30 crimes that are exempted from that bill. So the shortest list possible would be to use the very bad violent crimes list. But obviously it can be expanded beyond that as well.
Madam Chair.
Yes.
Madam
Delegate
Chair,
Scott.
speaking to the bill.
Oh, hold on. I have Delegate Scott.
I'll defer to my elder first.
Right. Delegate Lindsay.
I thought he was talking about Senator Morrissey, but I just pulled up a list real quick of Virginia violent crimes, and I'm always concerned about being asked to vote for something that we can't qualify. If there was an amendment that's specific, then I can vote it up or down. But when you say let's add some of the more violent crimes, just in looking at how we look at violent crime in Virginia, there are things like domestic violence, kidnapping, murder, sexual assault, and it doesn't differentiate. Sexual assault, voluntary manslaughter, involuntary manslaughter, gang crime, acts of terrorism, robbery, carjacking. Some of those things I'm happy to put in the bill. Some of those things, I'd have a bit of trepidation. To me, I thought the bill was about giving some compassionate release for persons who are terminally ill and expected to die within 12 months. So I'm thrown off a little bit about how the turn has happened in this this discussion. I understand that there are those who have some great concern about having any measure of compassion or any measure of consideration for any release earlier than that which was sentenced for persons who have been convicted of certain sexual assaults. I don't take issue with that, and I understand that the patron has been willing to accept an amendment to not have that offensive language in his bill. I'm concerned about how far we're going without having a real appreciation for where we're going, and that would be my only concern.
Right. Thank you. Delegate Scott, did you want to say something?
Yeah. Madam Chair, thank you. First of all, I want to thank the patron. This is a very noble, and magnanimous bill that you've introduced. And it sounds like to me that we have a group of folks who don't even want to let folks that we know will die, that are going to die soon, as determined by physicians, even be eligible to be reviewed for release. That's what this bill is. It's not saying that they would be released. I think the last study for geriatric parole, I think we had like a 3% release rate for geriatric parole. I'm sure the compassion is probably lower than that. We are not doing anything here that is going to change the trajectory of folks being released. This is about people who we 100% absolutely know are going to die in 12 months. And now we are saying, you know what? There are certain categories of folks that we don't even want them to be considered for release. My God, what kind of society are we becoming? I'm just asking everybody, please just move on, vote for this bill as it is. Don't water it down and change it anymore. Let the parole board consider these folks who are terminally ill and within 12 months of release. The patron said that the reason that he brought it and added 12 months to it because the 6-month period that was in there before was too short. By the time the application process got done, they were dead. We're not asking for anything. This is not something that I think is extraordinary. It's extraordinary to me that there are folks now who are saying, you know what? You don't even deserve to be considered for it. I heard my good friend, I think from Albemarle, Delegate Bell, say, well, somebody could come in terminally ill and get out. That's absurd. It could happen, but I'm praying that the professionals involved would not do that. And so I'm hopeful that, we'll allow the professionals, the parole board and the others and the professionals within DOC to go through this process and let folks who we know will die. They will not hurt anybody else. They will die. My God, we can track them if they're released. We can track a package from Wuhan to my house in Portsmouth. So we can track folks who are released. Let's stop using these scare tactics of and let these folks who are definitely going to die within 12 months get an opportunity to be reviewed and be released for compassionate release and die amongst their family in the hospital. Thank you. And save what, $85,000 a year. I know y'all want to talk about money, and they'll save $80-something thousand a year.
Thank you, Delegate Levine, and then Delegate Hope.
Thank you, Madam Chair.
Yes.
Delegate Scott said a lot of what I wanted to say. I would just remind everyone that this is a bill not to release people who are terminally ill, but a bill that allows people who are terminally ill to petition a parole board to let them out. If they're bedridden, I'm quite confident they'll be let out. They're no harm to anybody. If they're not, and they could walk around and they have a violent past and the parole board finds they are a danger to the community, I trust the parole board to keep them in. So I just think we have to distinguish between those folks who are a threat and those who aren't. And as Senator Bell pointed out, they have regulations that do just that. So I would recommend not amending it and leaving it in its current form. Thank you, Madam Chair.
All right, thank you, Delegate Hope.
Thank you. Just a point of order before I speak.
Yes.
Sure. I know there was a motion, but I don't know if there was a second to the amendment.
Well, because I've not really heard a motion. We were given options. Delegate Delaney asked for options, but I have not heard a list of crimes that, like a motion that these crimes should be.
All right.
Well,
then I won't speak to having any more carve outs. I will just say this though: the parole board meets regularly, and they deny parole, as we all know, regularly, and they do it based on the nature of the offense. They know how to look at offenses and decide whether that individual should be released or not. I have every confidence that they'll be able to make that distinction in this case. So I would oppose carving this up any more than it already is. And so I would move that we report the bill as amended.
Second.
Second.
All right. So it's been motioned and second to report the bill. Report and refer has to go to probes. All members wishing to vote, please do so on the electronic voting board.
Delegate Lindsay.
Delegate Lindsay votes yes.
Delegate Lindsay votes yes. Delegate Bourne.
Delegate Bourne votes yes.
Delegate Bourne votes yes. Delegate Campbell or Smith.
All right, everyone's voted. This bill is reported to probes 13-7. Thank you, Senator Bell.
Madam Chair, committee members, thank you very much for your indulgence and putting up with my passion on this bill for a long period of time. I appreciate all of you. Have a great day.
Thank you. Thank you. All right, I believe that completes our docket. That's right. So thanks to everybody for your hard work. The committee can rise. We're adjourned.